Good morning and welcome to the District of Columbia Court of Appeals. Apologies for keeping you waiting this morning. We have 3 cases on our calendar today. The first is 25 CV 284 Siemens Industry Incorporated versus GPEC LLC. Counsel, when you're ready, if you could come to the podium, introduce yourself and let us know how much time you'd like for rebuttal.
Thank you, Your Honor. Preston Zarlock of Phillips Lytle for the appellant defendant Siemens Industry. I would like to reserve 3 minutes for rebuttal. Your Honors, this is an appeal from a Superior Court's order, March 2025, which did 2 things. It denied Siemens' motion under the DC Anti-SLAPP Act, and it granted in large part Siemens' motion under 12b-6 to dismiss the 3 tort claims for failure to state a cause of action, except for one of them, tortious interference with contracts.
So, counsel, we've read the briefs. We're very familiar with the procedural history, and so I guess we'd like you to go ahead and focus on why you think the court was mistaken in concluding that the November 18th letter was not an act in furtherance of the right of advocacy on issues of public interest because it was primarily motivated by commercial or private interest.
Although, can I ask you to address one quick procedural point before you answer Judge Easterly's question, which is, are you still contesting the denial of anti-SLAPP dismissal as to the claims that were dismissed under 12b-6?
We believe it should have been dismissed under anti-SLAPP as well. Yes, Your Honor.
Right. Okay. So you haven't given up those claims. You aren't satisfied with the 12b-6 dismissal as to those claims.
The 12b-6 dismissal, I think, as the court held in American Studies versus Bonner, is sufficient under the second prong, the likelihood of success. I mean, if you can't meet 12b-6, you can't meet likelihood of success. But we believe that the court should have granted it all under the anti-SLAPP basis.
Maybe so, but what's to be gained by getting a ruling from, that to the extent the court erred in applying the Anti-SLAPP Act to those claims, that seems utterly harmless. Right?
I think that point is fair. I think you could make a distinction to the extent if this court were to reverse on the anti-SLAPP and we were to be awarded attorney's fees, to the extent the attorney's fees would apply to the work done on those other claims. I mean, I think there is a possibility there that there could be a distinction in the attorney fee award.
Okay.
Do you understand? There's been no, and I'm not a DC attorney. I've tried to read all the cases, but I haven't seen that specific issue answered yet.
Right.
In any of the cases. Okay. So in any case, I'll get to your question, Judge Easterly, which was, why was this wrong under anti-SLAPP? The court found that its communication, quote, clearly relevant to public health or safety or community well-being. In fact, I think that's hard to argue otherwise. If there's a fire safety problem, it absolutely is required. The court then, however, felt that because the letter had put a disclaimer in there saying there's all these problems, there's no fire system, which, by the way, is absolutely undisputed. It was admitted oral argument, it's admitted a complaint that there was no functioning fire alarm system. Okay. So at the end, we said, hey, by the way, we're not going to be responsible for this. So that was in the letter, there's no question. But the court held that under 16.501(2), we essentially had to make a third prong, and there's no third prong in the statute on that issue. We had to make a third prong of showing that it was not primarily motivated by private interest. And I think as a very fundamental matter, in any case where there's a public safety hazard, or in most cases for sure, there's going to be an interest to avoid liability. That should not undermine the entire purpose of the Anti-SLAPP Act. And I would direct the court, and the court's probably aware, even though it wasn't this panel, there was a case that came out just last week from this court, Capital Intelligence versus Waldman. It was different judges. That was Beck, Deal, and Long. But that had to do with a statement made accusing of corruption in a contracting matter. And the court went on to held that because the statement was clearly related to a topic of public interest, to wit, the preservation of historic mural, urban development, and the potential malfeasance of a particular developer, The motivation in making that statement, and it's, if you want the site, would you like the site? It's,
We can find the site.
Fair
I'd like to hear your point.
that, yeah, that the motivation behind a statement, which is clearly public interest, is, does not undermine, does not make it not on an issue of public interest. And this.
Right. I mean, we know that you don't look to the motivation, right? We've already said that in Fells, right? So you might have nefarious motives, but if you're, calling out on an interest of public, if you're speaking on an issue of public interest, that's the primary concern. But the definition of what is in the public interest also has a carve out for,
Does.
you know, private interests or commercial interests. And what I'm be interested in hearing from you is why you think, in my view, the question is, does the private interest edge out the public interest, right? Because you can have both.
Sure, absolutely. Court held.
And why do you think in this instance, in this November letter, the private interest did not edge out the public interest?
Because if first of all, the only reference to the private interest is a disclaimer at the end of mentioning all the things wrong and the public safety interest. Secondly, my point being, I think in virtually every case of this type where there's a public safety hazard, there's going to be some level of interest in avoiding liability. That does not mean that we don't want these type of statements to be made. And now obviously based upon the Superior Court's decision, if we had just struck the disclaimer, it is, but that doesn't really make any sense when the issue of safety, not commercial gain, is the interest. There's only two cases I think I've seen from the jurisprudence that are close, or on this precise issue. One would be the close it issue. In that case, there was already a pending litigation and the attorney's being interviewed and he said, yeah, they stole my money. Okay. This capital case, I think, is much closer, in a case where statements were made before any lawsuit was done about, and referrals about possibly some wrongdoing in something. And I think you're almost, I think we're all kind of wrestling with why the statute may have been drafted that way. But I think the only way to harmonize it is the impetus or the main issue, one of safety or of private interest. And by the way, if it were strictly, I'm sorry.
Well, go ahead, finish your
Let me
point.
finish my point. Then I'll answer your question, Judge. If it were strictly one of contractual pecuniary interest, okay, we would have not have copied it to the fire marshal and the DC things. It would have just been to the.
Well, but so that goes to my question. So two things. One, you say that the only indications of commercial private interests are the two disclaimers in the letter, but is a court not permitted to look at the entire context of the dispute between the parties, the relationship between the parties, and the context surrounding the letter? So here, the letter did arise in the context of a longstanding dispute between the two parties related to a purely commercial private relationship, private contract. Number two, my question is, once you mentioned the copying of the fire marshal, et cetera, I mean, that could be done. I'm not saying it was done here. We don't know, but it could be done intentionally in order to fall under the Anti-SLAPP Act when everything else about the letter is purely private and commercial. And, an enterprising party plaintiff might decide to, or I guess not a plaintiff at that point, but at the time they write the letter, the enterprising individual or party might say, let me copy the media here, or let me copy the government, a government entity in order to later have access to the Anti-SLAPP Act.
Yeah, I would say it's a good question, but I would say, for example, if you look at the capital case, that was a dispute about a contract, right? It was that I should have got the contract. I think there was something improper, and that was held to be covered under the Anti-SLAPP Act. So that I think is more on point in that. Secondly, all of these cases, to some extent, all the cases, most of which, with the exception of Close It, were held to have met the prima facie initial case, were cases involving private disputes. Whether you're talking about American Studies, where you talk about Saudi American public relations, they're all private disputes underlying them, but it doesn't mean that the contract of or the conduct of advising of a public safety issue should not be protected. And as a matter of fact, I think the course should consider that such a ruling that I cannot announce those things will have a chilling effect on announcing those things. When you get sued for defamation, tortious interference with a contract, these are all add-ons to what is at heart just a breach of contract claim. Furthermore, I don't think this really was a long-standing dispute until after all these things happened. There was a little back and forth. There's allegations which the court below found correctly were irrelevant as to who did what or who didn't do what. But
there are a
the
lot of
purpose-
emails with smiley face emojis where they're saying,
Exactly.
please give me, these, whatever.
Yeah, it was
the deliverable was. But can I redirect you? The trial judge said that Siemens had the burden to disprove private motivation, which seems incorrect.
That is correct.
Under our class,
Yep.
under our case law. Then it says at least that Siemens at least had its to carry its burden to show that the statement was not directed primarily toward protecting the speaker's commercial interest, and that Siemens has undertaken no such effort here. I'm trying to understand what the trial court thought you were supposed to do. What other evidence the court wanted you to put forward? Is there any other information that I should be looking at to discern that?
No, I don't. I think the letter speaks for itself. Okay. And I
Well, we
think,
look to the letter, and as Judge Schenker said, we can look to the context.
yeah, I think it's,
Conversation. I think that's clear from our case law too.
absolutely.
SAPRAC, we were looking at the initial blog post that the second blog post was
Yep.
responding to, right? So we can look to the context of this relationship. We can look to the letter itself. Is there anything else that we should be looking at?
I think in the record, I think the most important parts, both in the complaint of paragraph 37 and in the argument candidly admitted by counsel, is that there is no question that there was not a functioning fire alarm system. That's a matter of fact. That's not disputed. And I think that shows that there was at least at best, Your Honor, a mixed purpose here. Okay. And now if attorneys were writing these
I
letters,
keep coming back to the same question. How do we determine what the primary purpose is? And how are we supposed to discern that?
Or let me put it- If I may put it a different way, I mean, we talked about what the trial court thought you should have done, and we talked about the evidence. Can you elaborate or give us a sentence that says what you think your legal burden is under the statute as a person claiming, quote, protection under the Anti-SLAPP Act?
I think what's shown in, again, I'll quote from Capital, is he need only to show that his statements relate to issues of public concern. He's done that. These do. This wasn't by any means a pretextual situation. This was an issue of valid concern. And that whether the statements dovetail with economic and community broadly, whether there were any personal liability issues in there is not relevant to that. It's an issue.
Well, it's not relevant?
Well, it
I
is.
mean, you said earlier yourself, and we all obviously have to
Sure.
be aware of the language of the statute, and there's a definition, right? And it does speak in terms of statements directed primarily toward protecting the speaker's commercial interests, right?
Sure.
So it seems to me that primarily has to be given some weight. It has to translate in some way into what the burden is.
I think there's initial question, though, is obviously under the statute, private interests and commercial interests aren't really defined. Okay. And so in no case does that override the first part. And
Not that, I'm not talking about whether private interests are defined, but what the statement overall has to comport with, or where the weight of the statement has to fall.
Sure.
And it has to fall primarily on, I take it, by negative inference on the public side, right?
It does. And I think that's, to a certain point, that's the point that Capital's making. I think if you look at Nadal, right, versus this, the public linchpin there was quite weak. you had a lawsuit pending, you say someone stole my money. That's very different from saying people could die in a fire. And so, I think your question is very good, Judge Ruiz, that there is perhaps a balancing between the level of public interest involved and the possible private interest for avoiding liability. And keep in mind, in the case of Nadel, the private interest was to gain money in the lawsuit, right? I mean, there's been no discussion in the case law, and I think that's the reason I'm wrestling, and maybe you're wrestling, about whether something which is clearly a public hazard, avoiding liability for that is a private interest. Possibly, but it's not
I
defined.
don't think anybody's disputing that that's a public interest,
Sure.
right? But correct me if I'm wrong, you're not disputing that this letter had dual interests, right? Like to the extent that you disclaimed liability, that was a private interest. Do you agree?
Yeah,
Or are you
well,
fighting? Are you
I'm not, what
disputing?
I'm saying is the statute's unclear on that issue, meaning if the only
No, I'm
private
talking
interest.
about the statute.
I get it.
I'm talking about applying the statute and recognizing that our case law says you can have mixed interests and that that's not disqualifying from the Anti-SLAPP Act. Are you disputing that the statements in the letter describing your contractual or your client's contractual obligations and disclaiming liability, that those were statements in the private interest that were coupled with public interest statements? But are you disputing that there were statements in the letter that were in your private interest?
There absolutely were statements disclaiming, look, there's a safety hazard, we're not gonna be held liable for this. Okay, so.
And those were statements in your private interest?
They could be viewed as that. There's no case law.
I'm asking your position as you stand.
My position, again, with the benefit of no case law on that precise issue, is that where there is a certain public hazard, a bomb's gonna go off, a fire's gonna hurt, that was not, and unfortunately, I looked at the legislative history, it doesn't give any, let me finish, is that it's unclear that is the type of private interest to be contemplated, as opposed to, for example, me trying to replace him in the contract or get something that way, which is more private interest, just as a native.
I'm just trying to understand if you're presenting this case to us as a case where we sent a letter in and it was purely an act in furtherance of advocacy in the public interest. There was no private interest expressed in there at all, or whether you were saying, look, here is a November letter that had a public interest aspect to it. Sure, it had a private interest aspect to it too, but that private interest aspect was not the primary. And I thought we were in the latter category, but it sounds like you're.
No, what I'm saying is, we are in the latter category.
Okay, so we're in the latter category. My question, and this goes back to Judge Ruiz's question, is, I think we've acknowledged that our case law on this particular issue is undeveloped, right?
Yes,
this is a relatively
correct.
new statute,
Sure.
so here we are. What would be your rule of law statement for how one answers the question about when something is a primary private interest statement?
I would say that where it depends, as Judge Ruiz intimated, when the public interest is public issue, the importance, the safety issues are very clear, then there should be an extremely strong burden, not for the person arguing anti-SLAPP applies, but for the other party to show that it was almost solely motivated by private interest, which I think it clearly isn't here.
And why do you think this gets to another topic that I did want to ask you about? You suggest that it's the plaintiff's burden to show that the private interest, and it seems to me that the way the statute is written, that it's always the defendant, the party who's seeking the anti-SLAPP protections burden to make the threshold showing that they have engaged in an act of in furtherance of the right of advocacy on issues of public interest, right?
I
The burden
agree, yes.
shifts at the next step,
True.
but
But let me to explain my point in the first question. You're correct. Obviously, the prima facie showing of an issue of public interest is for the party asserting the anti-SLAPP. That's true. But as this court has held, and as you pointed out, we do not have to disprove the level or a private motivation within that issue of public interest, right? That's consistent with, as you cited, Fells, I think, you know,
But you have you have the sort of the continuing burden of persuasion.
yeah, I mean, yeah, but we don't have to disprove private interest is my point on that. Within our burden, we show that clearly it's an issue of public interest. And the issue of private is not upon us to disprove that was not primarily for,
Why not? Why isn't it your burden in the first instance as a part of your prima facie case to say there is a public interest and yes, we acknowledge it was a private interest, but it was not primary here.
Particularly since this is all coming from the definitional provision that has this private
Yeah.
interest carve out, and it just seems like it's all of a piece.
Okay, to tie in with the disproving, we've shown obviously that the issue is one of public interest to a point, at least on the safety issues. And then the reference in the letter, which is what this all comes from, is a disclaimer of liability at the end. There are, the reason for the reason it was sent to the parties it was sent was for the safety issues. Now, there was, as Judge Shanker said, well, couldn't you do that as a guise to bring it? Well, possibly, but there's been no evidence to that point. I think the fact that there might be.
That evidence wouldn't be relevant at this stage at any event.
Exactly.
So can I ask you a question? The CCing the fire marshal makes just sort of manifest sense, right? I mean, my understanding is that they have, you know, this authority to enter properties to make sure that they are safe. They've got police powers. They don't have the authority to sue, as far as I'm aware. So it would seemingly be it's a curious statement to say we can't be sued to the fire marshal because they can't sue them. So that would be to your benefit to say, we weren't saying we couldn't be sued to the fire marshal. That's not why we were talking to them.
Exactly.
The housing authority, it's not clear to me. Maybe you can point me to somewhere in the record after you sit down when you come back up, why the housing authority is CC'd, what the housing authority's relationship is to this property. I'm aware that the housing authority, you know, has contracts with some private entities to provide low-income housing in the district, but I didn't see whether or not this, in this record, and which we're, you know, bound to, it wasn't clear to me that that was why the housing authority was CC'd. The housing authority is not, for example, DCRA, which oversees the Department of Buildings, which would, you know, give building permits and issue stop work orders and things like that. So can you speak to me?
Sure.
Why they were CC'd to the letter?
Yeah, I think the starting point is this is not an attorney's letter, nor was it guided, nor is there any allegation that it was guided by counsel. This is a businessman, did an inspection, saw a safety issue, and alerted the parties they thought. You know, is it possible that they alerted the wrong party or that they were concerned with potential liability to a certain entity? Or perhaps they're concerned, you know, to the extent the liability issue, they're concerned with a personal injury case later. But the point is they're putting the people on notice they thought were important to know, which maybe they're wrong. You know what I mean? Maybe they did it the wrong way. It is a public statement to public entities. Was it the right entity? Maybe they should have added some more. But this is not something which was an attorney's letter or guided by counsel or intended to go to the right entities. It was just a businessman's alarm, no pun intended. You know, if counsel guided it, maybe we would have taken the disclaimer out.
It is a bit odd, this to whom it may concern. It's as Siemens Industry at the top as the addressee, but also as the sender. And then these CCs. And so if it's addressed to Siemens, why would it say Siemens will not be held liable for any non-operation? I mean, it's like you say, it's a bit awkward.
Yeah.
Can you remind me what, I know that there was back and forth between the general contractor and GPEC after this. Was there any reaction, response from the DC Fire Marshal's office or the DC Housing Authority?
There's nothing in the
upon
record and I'm not,
receipt?
yeah, there's nothing in the record and I'm not aware of that. I know there was a notice to cure later that's in the record between.
But that's a private.
Yes,
I
that's
was just
fine.
wondering that to the
No.
extent this was supposed to alert the public entities, the relevant public entities, did they act as if they had been alerted or that there was anything to be done here?
Yeah, not that I'm aware of, and there's nothing in the record to that extent, Your Honor. Again, it was, I think the intent was to alert the people who would have oversight of these things. Were they the right entities? Perhaps not. But it was not an attorney's letter. You could see it's almost done like a memo. You know what I mean? Yeah, exactly. This was not something which, in-house, outside, any counsel had anything to do with, as to giving the notice that would make sure it fell under this lap or didn't fall under this lap or those kind of things. It was a businessman's letter after a alarming inspection revealed a deficit, which is undisputed. No matter who didn't provide what or these kind of things, that factual issue is irrelevant, and that factual issue as to who owes money for the contract and things, that'll be decided in the breach of contract claim, which is going to go on no matter what this court does. So
And if this had actually been addressed to the DC Fire Marshal's office or housing, if it had been addressed to a public entity pursuant to some established procedure for bringing these kinds of issues up, and then CC'd to GPEC and the general contractor, I mean, it would be a clearer statement in terms of what is this, right?
absolutely, it would be clear. The letter, as you pointed out quite ably, is imperfect, to say the least. Okay, and it could have been done better. It could have been, but it still was, in our opinion, primarily to alert the public authorities of a possible undisputed danger issue.
Well, but let me take back, or now that you mentioned, or kind of repeated what I said. To come within the statutory definition, it has to pertain to a matter of public interest,
Sure.
but it doesn't have to be addressed to authorities. That would be an indication of what the purpose of the letter was, right?
It would strengthen.
It was advocacy in the public interest, but
Yeah, I think, what I'm saying is it could have made the case much clearer. Absolutely, had it been done differently, but I think Saudi American case, the statute is to be expansively applied on the front end, for the salutary purposes of these type of communications. I think, I don't know if the court wants to hear more about what happens down the road, or if that's something the court will. I've certainly exceeded my time.
I think
you have.
at this point, we'll let you sit down and we'll hear from opposing counsel.
Thank you very
Thank
much.
you.
It's been a pleasure.
Your Honor, may it please the court, Chap Peterson on behalf of Green Plus Energy Company, which in the record is known as GPEC LLC. I just want to read from I think the letter is really at the heart of this case, and I think it's worth, and obviously Judge Ruiz, you have it in front of you. It says, to whom it may concern, this letter is to advise that Siemens Fire Safety has visited the above-mentioned site as requested to terminate wiring and install devices into the Siemens fire alarm panel. During this visit, Siemens observed field wiring and device installation done by the local electrical contractor.
Well, I hate to interrupt, but we have read the letter more than once. So if you want to focus us on where you'd
So
like our
the
attention.
point I'm
to-
making is, if you read through the first 3/4 of the letter, it's all about, first of all, that's a false statement. We didn't do the wiring. We had not done the device installation, all this.
But whether or not it's false doesn't matter, doesn't pertain to whether or not it's in the public.
But
an
it
act
does-
of furtherance of the public
It
interest.
does pertain to the portion that says, the public interest shall not be construed to include private interests such as statements directed primarily towards protecting the speaker's commercial interests. And the purpose of this letter is to shift the blame. It's both to identify a situation, but also to shift the blame from Siemens.
Sounds like you're trying to argue that was the private motivations of
ma'am.
the letter. But under Fells, we've said that we don't look to the private motivations for the speech. We look to the content of the speech.
Well, then let's talk
And the
about it.
content of the speech is there's a safety hazard here. There's a wiring issue and this fire alarm system doesn't work, which you have not contested that the fire alarm system doesn't work. So it just seems like on its face, the content is true or false, right? It may not be true. And that is ultimately an issue that you'll deal with in the second step of the anti-SLAPP analysis, right? If whether or not you have a likelihood of success. But we're on the first step. We're trying to figure out if the Anti-SLAPP Act even applies. So on that step, why do you think this letter is not, if there's a public interest expressed in this letter, there's a non-functioning fire alarm system and a private interest, we have a contract and we don't want to be held liable. Why do you think that the private interest edges out the public interest in this letter?
Because all of the details that are given, which first of all are false, but secondly, all they collapse into basically this last sentence or penultimate sentence. It says, Siemens has not performed nor was contracted to perform any field wiring, device installation, or troubleshooting of the existing system. That is a disclaimer of liability. That's saying there's a situation
I
here.
understand that there's a disclaimer of liability.
No,
I'm
you're
trying
right.
to understand why, given the disclaimer of liability and the acknowledgement of a contract, but also an alert to government entities that there's a non-functioning alarm system, why you think
Your
when
Honor,
there's mixed motives, excuse me, which we have said are permissible, why you think the private interest edges out the public interest in this letter?
well, Your Honor, I'm trying to quote from the letter to show all the private content in it and all the private interest content. Ironically, I do believe that the cart is pulling the horse here because not only does Siemens say they didn't do the work, they also, for example, say that there was no approved set of drawings, which of course was part of their contractual responsibility. Then they go on to the last sentence, which is obviously the conclusion. Siemens will not be held liable for any non-operational life safety functions, activations, and notifications. The bottom line is, Your Honor, this perfectly fits within the carve-out, which says statements directly primarily towards protecting the speaker's commercial interests. Now, Your Honor, imagine that they simply sent a letter to the fire marshal saying there's a non-functioning fire system here, or the fire alarm was not properly installed, or the system is not properly working, instead of placing the blame on my client.
So are you saying that without the last two paragraphs, the disclaimer of liability and the disclaimer of that Siemens did the work and the disclaimer of liability, that otherwise this letter would be
No,
in the public interest?
Your Honor, I'm saying the exact opposite, Judge Shanker. I'm saying the last sentence says there is no fully active fire alarm system at this address. If you take that sentence out, then what's the public interest at all? You basically have two contractors that are disputing as to why there's a defective commercial situation. And I think if there had simply been a letter written to the fire marshal saying, hey, we have a fire safety problem, not assigning blame, and simply just saying that, then we'd have a different situation. But this was clearly a letter that was intended to shift liability. And again, we have to come back to the context. And Judge Easterly, I'll quote yourself back to you. You said the letter speaks for itself, which I agree, but we also have to look at the context of the letter. The context was we had hired Siemens to prepare the submittals, to make the submittals, prepare the drawings, to supply the parts. The parts went missing or were not delivered for 2 years.
So I asked your colleague on the other side if all of that context is relevant. And it sounds like you're, perhaps both of you are saying yes. And I'm trying to figure out where under the statutory scheme, the trial court and this court would be able to look at that context. I mean, we're at a motion to dismiss stage.
Right.
Obviously, we have a prima facie case under the Anti-SLAPP Act. Evidence is not coming in at this point, right? We've got the face of the letter.
I'm not agreeing there's a prima facie case under the.
No, I understand that, but at what point would either party have a chance to put in evidence of all of this external, extrinsic context?
Well, yes, and we submitted an affidavit, which for the most part just restated the allegations in the complaint, but just to sort of protect ourselves, we submitted the affidavit just saying we had a commercial situation. We had a vendor that had not supplied parts. The project was in a stalemate as a result of that. And the letter was written within that context, which accused us of using the existing wiring. And the record could not be more clear that we did not, excuse me, that we had not input in that wiring, that rather that was the existing wiring that we had walked into. And we put them on notice. I have an affidavit, I have exhibits, I have emails, all of which showed that we let them know that, and yet they misrepresented this fact, not just to the fire marshal. If they just contacted the fire marshal, fine. But they also contracted our general contractor.
It's just strange, and I realize this is neither party's, issue, but the statute, the way it's written, all of this seems to be a question for a jury in terms of, where the mixed motives line up. And you're talking about affidavits and extrinsic evidence, and I'm just not sure in a motion to dismiss stage,
You know what?
where a trial court would be able to consider.
Judge Shanker, this was all a little bit new to me, and obviously this statute is new, and I'm very familiar with the Virginia statute because when I was in the legislature, I helped draft it. So I knew about it from that perspective. My understanding of Fells was that if a case is made, you have the opportunity to at least put on evidence. We submitted an affidavit. It wasn't challenged. There was no motion to strike the affidavit. It basically restates the allegations in the complaint. There's nothing new to it. I don't know if you would have a mini trial on this. To me, I think what's really, and I went back and read every DC case on the anti-SLAPP, including the ones that some of the authors, members of this panel had authored, is that the statute is intended it's intended to discourage strategic lawsuits against public participation filed by one side of a political debate aimed to punish or prevent the expression of an opposing
Counsel,
point.
I see where you're going with this. It's just that we have case law that says we've looked at that legislative history and we have decided that that's not the boundaries of the statute as written.
Right.
And so the boundaries of the statute as written are, initially in this prima facie showing that you have an act in furtherance of the right of advocacy on issues of public interest. And I guess I'm asking you directly, do you think notifying government entities about a safety hazard is an act in interest in furtherance of the right of advocacy on issues of public interest?
Well,
Just answer that question.
That sole act alone,
Sorry. Do you think
right,
notifying a government entity of a public safety issue is an act in furtherance of the right of advocacy on issues of public interest? That is my only question to you right now.
Your Honor,
We can talk about how it applies to these facts, but just want to pin you down on that.
I would say on its face, yes, as long as the motives were.
Okay, you keep talking about motives, but in Fells, we said a speaker's self-interested motivations say little about whether the content of their speech is related to issues of public interest. In our country's fiercest public debates, some of its loudest voices are quite handsomely paid for expressing their views and are no doubt at least partially motivated by that remuneration. That does not change the fact that the content of their commentary relates to issues of public interest. So I really think that self-interested motivations, be it to take down GPEC or, interfere with a contract, have nothing to do with this prima facie showing. So we've settled now that notifying a government entity of a public safety issue is an act in interest of, in furtherance of the right of advocacy on issues of public interest. And the question here is, if you have a letter that does that and something else, right? And seems to protect a private interest, right? Says, hey, we've got a contract and we don't want to be held liable. That's a private interest, right? You would agree with that?
I think, Your Honor, what I disagree with is I think the analysis is exactly backwards. If the letter is written to the general contractor and it's basically
It's not
saying,
just written to the general contractor. It's written to a group of people,
well, it's
right? It's written to whom it may concern. That includes the fire marshal. I think the fire marshal is listed first.
Your Honor, again, I understand. My point is that this letter was, first of all, it arose out of commercial relationship. It arose out of a commercial dispute. It arose with a copy sent to the general
Okay,
contractor.
say I have a commercial dispute with Judge Schenker, right? We're in business together. And I think when we're building a house together, and I think that we're building it in a way that creates an extreme health hazard. And I notify the government that the way that we're building this property creates an extreme health hazard, right? We have a commercial relationship. And the reason that I know about the health hazard is because of our commercial relationship. But are you telling me that if I notify the government and just send a letter directly to whatever government entity would oversee or would rectify that health hazard, that that is no longer an act in the furtherance of the right of advocacy on issues of public interest because it arose out of our commercial relationship?
I think if that letter had false statements in it, that,
Where,
Your Honor,
okay, let's just agree to disagree.
I-
The falsity of the statements has nothing to do with whether or not it's an act in the interest of the right of advocacy on issues of public interest. Right? That comes in at the stage of whether or not you're likely to succeed on the merits, but I don't see how that undermines the public interest nature. I could be lying about whether or not Judge Schenker and I, whether there's a safety hazard. But my statement to tell the government about the safety hazard that may or may not exist is still qualifies.
Your Honor, I guess where I am is that, and I think I'm the same place where Judge Scott is, and I didn't agree with everything in her opinion, but she basically said the moving factor here was the protection of liability. The moving factor here was the disclaimer of liability. And I agree with her. I think that is what was.
On that point, can you elaborate, Mr. Peterson, on the relationship, possibly tension between this conversation we're having now and your assertion, your client's assertion of privilege because it had a commercial interest in making the statement?
Well, Your Honor, that's not my client's assertion. We say there was not a privilege. So in other words, there was a statement made against us that was false. We did not assert the privilege.
I'm sorry, you're
Yeah.
absolutely
So
right.
we brought up.
I should have asked him that.
Yes, yes, ma'am. So that's all right.
That's okay. So
And
let me ask you another
and-
question then.
And I have to sort of step back a little bit because again, I know we don't want to talk about the history of the statute and a lot of the other case law, but this is really a unique case. This is not a First Amendment case. My client's not a public figure. Nobody here is a public figure. This is a commercial dispute. And I understand that the statute is broader than just the case law. And Judge Easterly, I recognize that. But it is a little bit ironic that my client, who's a small business contractor, is being hit with this anti-SLAPP motion by one of the largest companies in the world. I mean, this is kind of where we are at this point, I guess. But, again, all I can do is come back to the context of our complaint, the letter that was sent, and that this was a commercial dispute. This was not a matter of public interest. If it had been a matter of public interest, they just could have sent a letter to the fire marshal and say, this is an unsafe situation. And frankly, I'm sure it would have been worked out, but the way it was directed to our general contractor caused it to be terminated. And that had a significant financial effect.
If we were to agree on that the complaint had a reasonable likelihood of success,
Yes. That's my fallback position, Your Honor, that
how do we handle do we actually get to that? If we don't, can we skip over the first point?
well, Your Honor, you could, and I think Fells gives you that option. Because of Fells, you could say, well, we find that this is a speech that qualifies under 16-5501. But by the same token, there's enough there to show that the plaintiff can succeed on the merits. And I realize that succeed on the merits is a lower standard than what you would normally see. It's sort of closer to a Rule 56. And we submitted an affidavit on that. We didn't really spend much time on that at
The
the trial
difference
court.
in Fells is that the court in Fells actually addressed that question. Did the court address that question here? The likelihood of success? Maybe it did.
I don't believe the judge did. I think
Right.
she just.
So in that case, why wouldn't we remand? Why would we reach out to address the likelihood of success issue in the first instance? We don't usually do that as a appellate.
Your Honor, that, you know what?
Now we review that de novo,
I believe you have the record. in
summary
front of-
judgment standard, we reviewed that de novo.
Your Honor, that's a good question. I'm not quite sure the answer as to whether or not
I
denote.
think that is the answer.
I think it is the answer. So
Yes.
there's your answer.
Which doesn't necessarily mean that we wouldn't remand.
I said, we did have a record and it just wasn't taken up by the trial judge or commented on.
Yeah.
All right. I appreciate your time.
Thank you, counsel.
Very briefly, Your Honor, rebuttal. Just to really quickly address the last issue first. We believe if the court agrees with us on the SLAP application, what was done on the 12B6, American Studies versus Bronner, can't meet the 12B6 standard, you can't meet likelihood of success, and I think that's controlling. Secondly, Judge Easterly, as you said, I think in Saudi American case, or your panel said, excuse me, I don't know if it was just you, generally the court won't review the likelihood of success at first instance. The court below did not. It looked at a 12B6 standard on everything. So that's just to address the last issue first.
Sorry, which case are you referring? to?
Saudi American
Saudi
Public Relations,
We affectionately call it SAPRAC.
SAFRAC, I'm sorry, SAFRAC. I'm not familiar. Quote, we disagree with the SAPRAC parties that we can examine this issue in the first instance. That's SAPRAC at 613, 242A3rd at 613. So I think if the court were to agree with Siemens, it would remand on that one issue because the 12B6 dismissals under American Studies v. Bronner kill any likelihood of success argument on those other claims. Now, getting back to.
Wait, I'm sorry. I may be slow this morning, but I'm
Sure,
not
no.
following that.
Yes,
If we were to look at it under the proper anti-SLAP standard, right? Why wouldn't we do it?
okay, if you look at the court.
Not 12B6, but as a special and as an anti-SLAP special motion to
Sure.
dismiss. We might decide we don't want to do that. But I'm just trying to understand why you say,
If the court were to determine that Siemens had met its initial prima facie burden, okay,
or that we need not, or we assume that they have.
then it kicks into the second part where
Right.
it becomes upon the plaintiff to demonstrate likelihood of success.
Right.
What my point being, the court below did not undertake a likelihood of success determination on
Understand
any
that.
claims, but the court did dismiss two of them under 12B6 and under American Studies versus Bronner, which I think Judge Easterly was on. The court said, look, if you can't meet a 12B6, you can't meet a likelihood of success. 12B6 is a lesser standard. So I think those claims would stay out. The only thing that would be remanded would be the tortious interference with contract.
That's what we're talking about.
Yeah, well, yeah, that would be the one that the court below under SAFRAC, excuse me, apologize.
That's
Under-
the one that the court never got to.
Yes, the court, that's the one, the court looked at tortious interference with contract under a 12B6 standard. And it held that, yeah, that is enough at the pleading stage.
And you could argue, at that point, it's the plaintiff's burden to show that they had a likelihood of success. And they're here before us now saying, look, we put on all of that evidence. The court didn't get to it, but you have all of that evidence before you. They're saying we'd like you to get to that now. So they're the ones with the burden of proof. They're saying we wouldn't be harmed. In fact, we would like you to
Sure,
address this issue. So why shouldn't we?
sorry.
Go ahead. The question is, why should we not do that?
The court, we did reach the issue why the court should decide they didn't meet it. It's in a reply brief, I think at page 12 to 16 or 17. So that's in there, okay, if the court chooses to. It's not for me to cabin the court's discretion. I was just stating what SAFRAC had said, where the court may or may not have had the evidence in SAFRAC, but they did not do the analysis. So I'm just relating what the court did.
We know the trial court did not do the analysis under this anti-SLAP act, but it's being argued to us that what was presented satisfies the higher burden under the anti-SLAP act.
Yeah, it does not. I mean, as he just admitted, the affidavit was the only thing they put in, just basically mimics the complaint in most instances. Does not provide any additional information as to damages, as to intent, as to the record also establishes there was a notice to cure they failed to meet. And so I
Is there
think
discovery?
There's been no discovery. This goes back onto what Judge Shanker said. The whole purpose, as this court has recognized in many cases of the Anti-SLAPP Act, is to avoid discovery, right? Because what happens is with anything of public instance, if you can drag people into discovery, right? That's why the courts have, with exception of Close It, always found that the first issue was met, at least from the cases I've reviewed. Because if you can drag a party into discovery, the purpose of anti-SLAPP is, if not eviscerated, severely weakened. Okay, so that's why the courts have traditionally said they met it, let's move on in virtually all cases. And I think the case that's very close, and I think our case is stronger, is the capital case. There where the recent case of last week where they notified the U.S. Trustee's office, I was defrauded in this contract. It arose from a contract. It arose from a private dispute that didn't make it primarily an issue of private dispute, and that was decided on the motion to dismiss. So
Can I ask you one more question about sort of the scope of the relief that you're requesting? You said when you were up before us initially that it was your position that the trial court had gotten the anti-SLAPP ruling incorrect, and so you wanted us to reverse that ruling, and that you indicated that that would apply to all three claims. And so it would seem that you were then asking us to vacate the 12B6 ruling that was in your favor, so that then if you got the benefit, this is hypothetical, but if you got the benefit of this court saying you had met your prima facie case, the burden would then shift to GPEC to show that they had a likelihood of success, and they could take another run at showing a likelihood of success on all three claims. Because I don't think that I'm trying to understand procedurally how we could remand on the Anti-SLAPP Act and leave the 12B6 ruling in place. That would seem to be perhaps procedurally improper.
all right, so let me explain. The court, you came up with a question which really had not been considered below or.
I'm asking, I'm also kind of curious whether it was.
We're not asking.
Whether it was actually briefed to us.
Yeah.
I read the brief really as challenging the court's anti-SLAPP ruling on the tortious interference.
Yeah, that is, I am not asking the court to clarify. I am not asking the court to vacate the 12B6.
Okay.
Okay. What I'm asking the court to do is to, on the tortious interference claim, to find that the anti-SLAPP prima facie case was met, and then to proceed from there on that first claim. And I think that's consistent with the court's jurisdiction as I've read it under Mann. So I apologize if I.
Okay, so you're not asking for you're not asking for anti-SLAPP to apply to the other two claims.
We're not asking for vacate. The issue that rose, which I told you raises a very interesting question, is assuming, and this has been, this is a fascinating case based on the lack of, decisions right on point. But assuming the court were to do what I'm asking, which is find that we made prima facie case on anti-SLAPP, on the tortious interference with contract, send that back for them to try to show that they made the likelihood of success showing on that claim after the burden shifts. And let's say they didn't do that. And then that would trigger, I believe, the attorney's fees provision. So there is a very interesting question on what portion of my attorney fees, if I were successful, I'd be awarded, right? Would the lower court, and perhaps this court on appeal, then say, no, part of your work was for these other claims that you won on 12B6, not for this, so you can't get all of that? I mean, that was we had an interesting intellectual discussion.
I hear you saying that is downstream and not anything that we need to worry about.
Yes, correct. So anyway, fascinating case. Thank you, Ron.
If I may, just one last thing, since I misdirected the question before. Tell me the relationship, if any, between your claim that the Anti-SLAPP Act applies and your claim of commercial privilege over the statement.
Yeah, there is as this court is held, when it goes into the second phase, right? Meaning once the prima facie, then it goes into likelihood of success determination. And in the likelihood of success determination, and this I think underscores why the court below, or that the court below did not fully do that analysis, we're entitled to then assert any defenses, objections, or things at that stage. Okay, so there is the fact
And
that a
what do
party,
you, in order to assert that defense, what do you have to show? What's your burden?
well, there's the factors, like the case, how you pronounce the
There's
case.
those like.
There's
a
7
lot of
factors.
Right.
There's 7 factors, and we believe we can show that, but that the court never really reached that issue. It's not, and I think where this court has found as it's not contrary to there being a slap application.
We have addressed that issue?
Yes, exactly.
Okay,
Okay.
we have.
Yeah, if the court, we've gone back and forth on what the court can do on the likelihood of success issue. I cited Saudi American for what the court had done previously, but I don't think the court below engaged in a full likelihood of success analysis, submissions and things, but.
I don't know, maybe I'm not making my question
Sure.
clear enough, which is, does the determination of whether there is a commercial interest privilege over the statement have any bearing on the determination whether the statement itself falls under the Anti-SLAPP Act?
No,
It
it's
does
a
not.
separate defense. It's a separate.
I
defense.
understand that you
Yeah.
get to it as conceptually, can you assert both? This is a statement primarily for advocacy for a matter in the public interest, and at the same time, it was privileged because we have such a strong commercial interest in it.
I believe, yes, you can. I believe you can. There isn't a case right on point.
That's what I
Yes.
thought you just said that there was.
No,
There
no.
isn't. I
There
didn't
isn't a
think
case.
so.
I'm saying there is a case, it begins with an O, that talks about all the factors.
That's the factors to establish, and I'm just
No,
trying to link
there's-
those two inquiries. And is there a relationship between them?
Not believe.
Is there some inconsistency
No,
in your
I
position?
don't think
based-
so at all. I don't think so at all. To say
You
that
don't
this
think
was
so?
not, yeah, we don't have
Yeah.
to disprove commercial, motivation. I believe this clearly.
There is no case.
There is no case on point.
Okay,
Absolutely. Like,
Thank you.
like many things, there's no case directly on point. Thank you for your time today.
Thank you, counsel. We appreciate your time today, your extended time today, and the case will be submitted.
Thank you.
Yes, sir. The second case on our calendar today is 24 CV 1151. It's REMUS Enterprises 1 LLC versus QUINN BREECE. So when you're ready, you can come to the podium, introduce yourself and let us know how much time you'd like for rebuttal.
You good morning, Salon Phillips for the appellant Remus. And 3 minutes for the rebuttal, 15 for.
The arguments are sort of loose, so yes, we'll make sure you have enough time.
Okay. So as you know, we're here on the appeal for dismissal on the complaint that had the slander of title and the tortious interference of contract. Before I get into the merits of that, I would like to address the standing and the jurisdictional issue, which seems to be somewhat convoluted. Remus Enterprises 1, has always been the entity that we're going to be discussing. The difference was actually brought about from opposing counsel. Remus Enterprises 1 is a rehab construction company that primarily deals in the district. But it was originally formed in Maryland. So in July, it decided to be incorporated in DC and just transfer everything over from Maryland. So it was canceled in Maryland and then formed in DC. But DC alerted the owner, myself, that you can't transfer a canceled entity. So it went back to Maryland, incorporated or reincorporated REMUS Enterprises 1, and then made the transfer. And that was the reason why there was two
So, Mr.
REMUSes.
So, Mr. Phillips, I understand that, and there's some information in the record on appeal supporting that, but it's not, I mean, that at this stage before the trial court was confined to the complaint, right? And so, there's no indication of that in the four corners of the complaint as to why there were two separate entities. So from the face of the complaint, is it correct that the plaintiff, the named plaintiff in the complaint, is a separate legal entity from the party identified in the numbered allegation, and I don't have the numbered allegation in front of me, that is alleged to have owned the property at issue?
No,
That
the plaintiff on the complaint is the party that owned the property that was harmed by the defendant's actions. REMUS Enterprises 1, comma.
So what was the status of REMUS Enterprises, comma, 1?
It was dissolved. It was dissolved in July 2023.
Right, is that before the complaint?
Yes,
Okay, so in the complaint allegation that says REMUS Enterprises, comma, 1 LLC owns the property at issue, is it your contention that that was a mistake or a typo?
yes, that must have been a typo, because again, it was dissolved in July. So that the property was initially purchased in February of 2023. The contract name had REMUS Enterprises 1, comma. That's why I initially said that it's always been 1, comma. It was never made clear that it was actually comma 1. So following the purchase of February 2023, in July now, that entity was dissolved. November of that same year,
2023?
yes.
Okay.
In November of that year, REMUS Enterprises 1, comma, now became an official entity. The name was already on the contract for the purchase of 16th Street, because that's what the name always was, but legally it was comma 1. But now in November, when REMUS Enterprises 1, comma became an entity, then the following year in March, when the lawsuit was filed, that was the entity now that owned the property and was harmed by the defendant's actions.
So the plaintiff, which is, looking at the complaint, 1, comma, this is what you're saying,
Right.
right? Is described as a registered to do business in the District of Columbia. So this is supposedly, this is the entity post all those changes.
Well, it was registered again in Maryland because it had to have been registered in Maryland in order to transfer over to DC.
Right, but the complaint identifies it as a limited liability company registered to do business in the District of
It's
Columbia.
domesticated, registered.
Registered
Yes.
to do business, so,
Yes.
yeah.
Yes.
So it's not actually incorporated here. Well, it's an LLC.
Correct.
Yeah.
That's correct.
So when you say transfer, you just meant registered to do business?
Well, the idea was to transfer it and actually make it a DC corporation.
That did not happen?
That never happened. So back history, what happened was REMUS Enterprises incorporated a totally different.
There is at one point, and I'm struggling now to find it, I'm sorry, among my papers here, an order by Superior Court judge. Basically, I think it's pursuant to a stipulation that lists all of these properties and says kind of who owns what.
So that,
So who owns, according to that order, if you could tell me the date of the order, please, and which of the entities is determined there to own the property, the
Right.
13th Street
so the
property?
date of that particular order, I believe, is November the 6th. Now simultaneously,
November the 6th of
2024.
2024.
Now, that was a consent order.
Right,
That was an order that was entered into in order to just sell this property.
the Dickersons.
Right,
Right.
because remember this, they entered into the contract earlier this year, but we couldn't sell it because of the less pendants that they had on the home, and they were asking
Understand.
for money in order to release it. So simultaneously, there was a case in Maryland over this same, basically the same issue. So a few days before the consent order was signed, Maryland's order came out and said, this guy was never an owner, he was never a member, he was nothing. So
Who is this guy? Sorry. Can
the
we-
plaintiff in the case, in the DC case, Yanni Nasi. This was the claim that they were representing.
That was not about the ownership of the property. That was about his membership or participation in the LLC,
Well,
which
that,
said in turn owned.
well, that's what they were trying to use as an ownership claim. But he wasn't an owner of the LLC, he
And
wasn't.
then that list pendants was withdrawn.
Exactly. So the Maryland ruling in summary judgment negated basically the need for the consent order. So the consent order that said Remus Enterprises 1, never had any ownership, that was just to allow the closing to proceed. But then when the Maryland order came out, then there was no need for the consent order.
What's your point in saying there's no need for it? Are you trying to say that it's not valid or not enforceable or has?
Because the whole purpose of it was to remove the less pendants, and the
I
Maryland
get
order.
it. I'm just asking, are you trying to tell us that we should not rely on anything in the
Right.
consent order?
Correct.
Did you ask for the consent order to be vacated?
No, there wasn't, again, there wasn't a need for it. They voluntarily removed the less pendants once the Maryland order came out.
But when did you issue the consent order visa? When did you consent to the consent order visa?
It was a few days after the Maryland.
So why did you consent to it if there was no need to it? I mean, you get an order from a court. Courts don't go around issuing orders that they don't need to issue generally. And if you don't want that order to be binding on anyone, you generally have to ask the court to vacate that order. But if you have an order that says Remus Enterprises 1, has no interest in this property, it seems like that has some legal effect unless and until that order is vacated, right?
Yes and no, because it totally conflicts with the Maryland order.
Maybe so.
No, it doesn't.
I mean,
Why, wait, why does it conflict with the Maryland? Maryland order has to do with one individual's level or participation or non-participation in an LLC. The DC order has to do with what LLC owns the property. They're different things.
Yeah, I guess what I should have said was the effect of the order. The effect of the consent order again was.
That might be, Mr. Phillips, but you know, here we as a court, we have a motion to dismiss with really no documentation to speak of. But we do have this order of Superior Court. We can take judicial notice of that order, even though, because, you know, it's order entered by court, public record, in fact, mine's your company, right? And that's telling us, so just tell me, because which entity does that order say own the property as of?
That consent order, which was entered, by the way, 8 months after the filing of the complaint that we're discussing here.
Right, because I want to get to the issue of time,
Right,
because
says that,
it's
I think
critical.
we consented that Remus Enterprises, 1.
Comma 1, which means the new,
That's the old one.
the old one.
The one that was canceled before any of
So
this.
as of November 6, 2024, even though it shows, because it's that entity that is ordered to transfer the property to in that order.
I don't remember if the order
It does.
It orders the.
It does indeed. I don't remember which entity is ordered to do it, but there isn't, part of the order is that the property shall be transferred to the Dickersons.
Yeah, so yeah, definitely.
Yeah.
But it wasn't transferred from one REMUS to the other REMUS.
No, to
Okay.
the Dickersons.
Okay, yeah, that's what enabled us to close and for them to move into.
But you're saying that it was the original REMUS that was deemed to be the owner and that was ordered to transfer the property?
Yes, if the.
You don't have the order in front of you.
If the consent order consented a REMUS to convey it to the purchasers, it would have been the REMUS Enterprises, comma, one, but then that didn't happen because the REMUS Enterprises one, comma, was the owner of it, and they.
We don't talk about commas and ones, but new and old or first and second. It just gets really.
It gets very
confusing.
confusing, yes, it
Yeah.
does, yeah. But the point that I'm making is that the entity that brought the lawsuit was the entity that was harmed by the defendant's actions.
Right.
They were the ones that entered into the contract with the listing agent. They were the ones that entered into the contract with the purchasers. They were
Can I just ask?
And
a-
is that the entity that is in front of us? So that-
yes.
It is?
It is.
But is that because you're saying it's the same entity? That the
No,
two
no,
entities are
that's-
one and the same?
No, that's
No,
the entity.
It's
that's-
the entity,
Yes,
because
it-
that's the one that filed the complaint.
Exactly.
So, I just want to make sure I understand the facts. You're saying the old entity bought the property in February 2023.
Right.
Even though the complaint says the plaintiff purchased the property in 2023 and the plaintiff is the new entity.
Plaintiff is the new entity.
Okay, so where is it documented that the old entity bought the property in 2023? In our
Yeah.
record?
It should be in the complaint, but if it's not,
Well, the complaint says in February 2023, plaintiff purchased the property and plaintiff, as we have just said, is the new entity.
okay, yeah, so that's.
So, okay, so, but you're representing the old entity bought the property in February 2023. The old entity was
Oh,
dissolved.
well, let me correct that. So in 2023, the name Remus Enterprises one, comma, purchased the
Let's
entity.
go old and new.
Okay,
Old entity is Remus.
okay. So the
Enterprises
old,
only.
the,
Right,
the,
no.
the old entity, which has a comma before, legally purchased the property.
February 2023.
Yes.
Okay, and we don't have that in our record, but that's your representation to us here. You're saying the old entity was dissolved in July 2023?
Correct.
Do we have that in our record anywhere?
It should be in the complaint or somewhere in,
Okay, then you say the new entity becomes an entity in November of 2023?
correct.
Is that in the complaint?
I don't have it in front of me, so I don't want to.
Okay, I'm not seeing that. And then at some point, you're saying that the property is transferred from the old entity to the new entity? When does that happen?
So once when the old entity was dissolved in July, the property, I guess, was in legally it would revert to the only member of the LLC. So once when the new entity was formed, it was believed that the new entity was still the old entity.
There's a gap, right? The old entity is dissolved in July. The new entity doesn't come into existence until November. So who owns the property in between July and November?
The sole member of the LLC.
That's, I'm sorry, I can't remember.
It's you.
That's,
Yeah.
yeah.
That's you. Okay.
Can we touch on the merits of the 12B6 dismissal, unless my colleagues have more questions on this point? With respect to the slander of title claim, can you tell us what the false or malicious statement in the lease pendants notice
Yes.
is?
So there was two less pendencies that was filed.
Well, there's only one that's at issue in the complaint. in
Right,
the
so
operative
one was filed and then
complaint.
one was removed and then the other one was filed. And it suggests as though there was a dispute between who owns. There was no dispute as to who owned. The suit was
Is the
brought,
list pendants in the record?
is there a list pendants in the record?
Yeah, you didn't attach it to the complaint and it's not in the pleadings for summary judgment. So why is it before us?
There was no summary judgment.
I mean, sorry.
To
but
dismiss.
For the motion to dismiss.
Right, so there was a motion to dismiss and the trial court,
Wasn't an exhibit to,
well, it wasn't an exhibit. And
Right,
the position is that there was not a need to attach it as an exhibit because the allegations were to be taken as true. Now, discovery would have brought about the actual list pendants and everything else, but we didn't get to that point. At that particular stage, it should have been taken as true and we should have moved forward
We
with.
quote from part of the list pendants in the complaint,
Yes,
right?
yes,
And specifically, it says, the list pendants filed on the property states that, quote, Mr. Phillips claims that his new LLC has taken ownership of all the assets of the original REMUS, including the subject property. Right?
correct.
And then it says, that was paragraph 29. Paragraph 30 says, this is not true. No such claim was made and no such transfer has taken place.
Correct.
These are basically the meat of your allegations concerning the slander of title. Is that
Right.
correct?
Right, and so the trial court alluded to the fact that the list pendant should have been included as an exhibit. And our position is at this particular stage, it should have been taken as true. And later in the litigation, the list pendants could have been entered into as an exhibit.
But the list pendants is describing, and its whole purpose is describing the underlying suit, which challenges ownership. And the list pendants by design and definition is supposed to describe the claims and the nature of that lawsuit. So if your position is that the claims in that underlying lawsuit are false, does that necessarily mean that the list pendants' description of those claims is false?
Yes, and the case in Bloom was dealing with the statute, a 2001 statute that basically said it doesn't matter what the list pendant says as long as it's making reference to the property. The amendment in 2010 added something more specific about ownership. So you have to have a claim of ownership to the property. The Bloom, in a footnote, they mentioned that, but they didn't apply that standard to the case, which is why it was overturned. In this particular case, they make a claim of ownership, but it's a totally false claim. They say that Mr. Nasi, who is a member of this LLC, which he wasn't, has a claim to the property. But even if he was a member of the LLC, that still wouldn't have given him a claim to the property. So what they essentially did was they falsely put a list pendants. And if you think about it, if anyone just goes on Zillow, right, and they see someone who's going to buy a house, they can put a list pendants on that home to prevent the seller from selling the home and then go to them and say, hey, if you want to sell this home, give us
But Mr.
10,000.
Phillips, that is not this, what you just described as being in the list pendants, as being a false claim of ownership by Mr. Nasi, is not what your complaint complains about.
But the slander of title is that he made a false statement in the list pendants, and he did.
I just read you what the alleged false statement was.
I don't even see that. I don't see
It is that
Mr.
Mr.
Nasi
Phillips
referenced.
claims that his new LLC has taken ownership of all the assets of the original REMUS, including the subject property.
So the falsity of that is one, that above that, they said there's a Nasi versus Remus claim. That's the name of the action, right? So the plaintiff in the action that's filed that initiated the quiet title claim is a random person who's not even a member of the LLC. And then later on, it goes down and it's worded very carefully.
When you say above that,
I think it's line 4 or 5 of the list pendants.
You
Well,
Have the list.
complaint, Mr. Phillips, we're looking at the complaint that you filed.
Okay, so.
That's that's what was in front of the judge. That's what's in front of us. And unfortunately, it's not what's in front of you right now. And which is surprising that this is an appeal about the dismissal of your complaint. And we're all looking at the actual complaint and you're not.
Pretty much had it memorized. So the complaint, the addressing Judge Shanker's question, the false statement in the complaint is that there was a dispute over the ownership of the property, and there was not.
But that, I mean, there necessarily is, if there is an underlying lawsuit that alleges a dispute about ownership of the property, right? I mean, you may have a challenge to that underlying lawsuit, but the lease pendens is posted to provide notice that there is such a lawsuit that disputes ownership of the property. So it would be, your argument would be that every lease pendens is false and malicious if it is providing notice of a lawsuit that the owner of the property thinks is an incorrect lawsuit.
No, that's not what I'm saying. I'm saying if any random person were to file a lawsuit claiming that there's a dispute, even though there's none, then that is a false statement in the les pendens in and of itself. Again, and so I was using the example, if you're trying to sell your house and I file a les pendens saying that I own it.
Well,
I'm your
you wouldn't be
cousin.
able to, you'd have to file a lawsuit first, right?
I'm sorry?
You'd have to file a lawsuit first. You couldn't just file the lease pendens.
Right, if I were to file a lawsuit in the same day, file a les pendens, and in the les pendens, I say that there's a suit between me and Judge Shanker, and there's a dispute over the ownership of this property. I'm the owner, even though I know I'm not. But then right when it's filed, I go to you and I say, if you want to sell this house, give me some money and I'll remove the les pendens so you can sell, because no title company is going to ever allow you to sell your house with a pending lawsuit, regardless if it's fraudulent.
I mean, I think that's just somewhat unfortunately the nature of the lease pendens, which is that it's designed to put the public on notice of a lawsuit that, for better or worse, has been filed and docketed.
Yes, but I think the amended statute suggests that it has to actually be a true lawsuit. It can't be a lawsuit that's based on falsity, because then it just ties up a sale.
The problem in this case seems to be that the facts that you're hypothesizing here are not akin to what you alleged in your complaint, right? You didn't say in your complaint, oh, defendants are claiming an ownership interest that they don't have in the property. You assert in your complaint at paragraph 30, the list pendants states that Mr. Phillips claims that his new LLC has taken ownership of all the assets of the original REMUS, including the subject property. And then you say, that's not true. So there's no point at which you pinpoint a false statement by Mr. Nassi or his attorney about ownership of the property. It's the false statement is about your ownership of the property.
Well, yes, the false statement in the les pendants is that there's a dispute over the ownership of the property.
Well,
As between the two LLCs. As between the two LLCs. That his new LLC has taken ownership of all the assets of the original REMUS, including the subject property.
Right.
That's what it says.
Correct.
That is the ownership dispute that the list pendants is referring to. I don't think it has to be Mr. Nassi's own personal interest in it, but this is a dispute that the lawsuit apparently,
And there was no dispute over that.
and that you say in your complaint, it's not true. No such claim has been made by you, because it says that you had made that claim.
Right.
And that no such transfer has taken place because and that's why I'm still looking for that order that establishes who owned the property when as between the two LLCs.
Right, and it doesn't, that order, the consent order doesn't say as to when,
Doesn't say as to when,
does not.
but it does say that the first LLC is the one that owned the property.
Yes, in November, after the lawsuit was filed, it says that the consent is that REMUS Enterprises, one, the
Well,
first,
the first
the first,
owned the property.
correct.
So that would be consistent with the allegation in your complaint that there was in fact no transfer of ownership to to the second LLC.
No.
All right.
At the time of the complaint was filed and time of the less pendants was filed, there was no such transfer, there was no such dispute, which is why the complaint was filed. Because there was the less pendants and the language in the less pendants was totally false. Now, before the property was sold,
I mean, it was true to the extent that it was saying that a suit had been filed alleging these things, right? That's all it was representing, that there were.
oh, no, well, again, the slander of title is the language in the less pendants that we're talking about. Language that's on the less pendants that shows up in the land records. You can't have anything that's not true in that. That's what the public sees. And what was not true in that less pendants that was made public was that there's some sort of dispute over the owner of this property.
Specifically that the new LLC has taken ownership.
Correct.
And you're saying that was false?
Was false. At that time, when they filed the less pendants in February of 2024, that was false.
That was false in 2024. Did it subsequently become true?
Yes, it subsequently became true once when it was brought to our attention that there was a misplacement of the comma and that made two separate entities. So now, in order to move forward with the actual sale, it had to have gone from REMUS, the first one, to the second one. So at that time.
To comport with the deeds?
Correct.
Why weren't this is an aside, why weren't the deeds reissued in the name as opposed to doing the whole transfer from one LLC to another?
Because there was the same company, same owner. So the title companies just had me sign.
Yeah.
But it was never any like intention, oh, let's come together and move the comma to make it. Trust me, no one knew that it was going to come to this. But the point is, in February 7th, exactly, when the less pendants was filed, it made a statement that there was a dispute between the old REMUS and the new REMUS, and therefore we're stopping the sale of this house. There was none. The malice comes in because the email came directly from opposing counsel saying, hey, put all the money in the escrow and we'll remove it. Give us all the money from this sale and then we'll allow you to sell the house. We'll allow these innocent people who were trying to move into a house to
Escrow, but escrow doesn't mean that they get it, but what was
their escrow account.
Their escrow account.
Yes, that's what the email says.
And okay, none of this is in the record, of course.
I think it is part of the record in the appellate record.
Well, I
All
mean,
we
is
have
it-
is the complaint.
Is it in the complaint? Right. I mean, this was on a dismissal.
All we have, I mean,
Well,
things were put in an appendix, but they were not part of the record before the trial court,
there was a motion for reconsideration and that I think.
which isn't even brought up in your brief.
I mean, was the point you just made 30 seconds ago alleged in the complaint? The reference to the email and the escrow, all of that, is that in the complaint? I should know this, but.
I believe it was.
Okay, well, we can.
In under the interference of contract.
We'll take a look at it, counsel. We've kept you up at the podium for long enough, and we'll hear from counsel for Quinn BREECE. We'll let you come back up on rebuttal.
Good morning, may it please the board. Jude Vikramanayakar, representing attorney Quinn BREECE. I'd like to start by, first of all, noting that the consent order that we've been looking for is in actually appellee's appendix at number 10. I think
Please
that,
appendix at number 10. Thank you.
yes, page 10. And in that consent order by Judge Dason, that clearly indicates that there are two separate entities.
Yes, that's not disputed.
Right, comma one old, one comma new. What's interesting is if the other omission, I think, from appellant's appendix was the actual original complaint, which we added to our appendix at 1. That's the first document we attach. I think what's very interesting is if you look at the first complaint filed in paragraph 14, Mr. Phillips says, REMUS Enterprises, comma 1, old entity, owns the subject property. He says that. Then we look at the amended complaint at record 4, and it says REMUS Enterprises, 1, comma, has always owned the property. Two completely contradicting statements in his own pleadings. It is for that reason that Ms. BREECE, as counsel for Mr. Nasi, who was a member of the LLC, and that is in record 66, appellate's index.
Isn't there a Maryland court order saying that he wasn't and never was?
Yes. That is,
So how come you're telling us that he was?
well, that decision is up on appeal. And
All right.
in 66, the record itself, Mr. Phillips and Mr. Nasi signed an operating agreement of REMUS Enterprises. Admittedly, it says 1, comma, but that's the membership agreement that says he's a member. Now, even if we don't accept that fact, right, as the Maryland court stated, Ms. BREECE filed the lis pendens because of the inconsistencies in all these entities. She basically said there's a comma 1, there's a 1, comma. We need to know who owns that property. There's a dispute of fact of that issue. And that's all she said, which, as Judge Easterly said, is a truthful statement of the lawsuit. We don't, in order to prevail on this or to defeat his claim of slander of title, in my opinion, we don't have to show that our lawsuit is meritorious, merely that it was in good faith, which I
So the fact that you file a lawsuit, and it could be, as Mr. Phillips said, completely false assertion of ownership and actually fraudulent, ill-motivated, whatever. And so long as a lis pendens reflects the fact that such a lawsuit has been filed, the lis pendens is safeguarded from any kind of slander of title claim.
I think there's a conditional privilege, and I think that we have to show good faith. So I don't think that we get to the issue about false.
You have to show good faith
Correct.
on behalf, but
Under slander of title or under tortious interference?
I think I believe the defense, in my reading of the case, would be that it would apply to both. I mean, our argument on tortious interference is a fewfold. Number one, we were not aware of the existence of the contract, and that's was not pled in either pleading. And Judge Williams.
we're not in the existence of a contract. Now we're getting to the, I'm sorry, there is a complaint does refer to a listing agreement.
Listing agreement, but
That's a contract.
But in terms of the contract of sale, I
Well,
believe
that's a second contract.
right. And then the issue is there was no evidence that we were aware of it. And it was never produced in the listing agreement, in my opinion, was the agreement for whatever REMUS entity owned the property to use a broker to
Mhm.
advertise the property for sale.
Oh, you're saying, you're going to the point about awareness of the existence of the contract, not
Yes.
that there was a contract.
Yes, Judge
Okay.
Williams said, I haven't seen a copy of the contract. There's no evidence, and it wasn't set forth that Mr. Nasi or Ms. BREECE was aware of any contract. All
Of a specific contract, as
Correct.
opposed to knowledge of that they're in the business of,
knowledge that at some point this property was going to be sold, correct? That's why in part the
But
tortious.
going to the slander of title
Yes.
count, why aren't paragraphs 29 and 30 sufficiently pled? Why don't they sufficiently plead that there was a false statement that slanders the title?
May I ask, are we,
Looking at the complaint that was filed,
okay, so there's an amended complaint.
looking at the complaint that was filed, paragraphs 29 and 30, I've read them a couple of times.
So paragraph 29 says the lis pendens filed on the property states that Mr. Phillips claims that his new LLC has taken ownership of all the assets of the original REMUS, including the subject property.
That's a pretty specific factual assertion, right? And I assume it's accurate? I don't know. I don't have the list pen.
Unfortunately, I don't have the.
Well, it doesn't matter. I mean,
Well, it
we're just looking at the complaint. Okay, it's a specific factual allegation of what is claimed to be a false statement.
The next paragraph says that is not true.
This is not true. No such claim was made and no such transfer has taken place. Well, that's a factual issue in dispute. It doesn't mean that it was
We're at the complaint stage.
correct, but it's a complaint for slander of title. If we have a good faith belief that that information was true.
That would be your defense to the lawsuit.
Correct.
We're looking at the sufficiency of the complaint and whether it is the allegations are factual and specific enough to meet the standard, which, as you know, is fairly low.
False and malicious. And I don't believe, I think one of the issues Judge Williams had with the complaint was that, number one, even assuming that this wasn't a good faith attempt, the issue is, what was the malicious communication? Why was it malicious?
Well, I mean, isn't the absence of good faith pretty much the same as maliciousness?
Well, I don't think so. I think that if we have, I think malicious has to be some type of an intent to cause harm or do damage. I think there, and I don't believe that the court found that there was a lack of good faith. In fact, these two paragraphs don't necessarily say there wasn't a lack of good faith. I understand that Mr. Phillips' opinion, but Ms. Breeze filed this lis pendens based upon the fact that there was two LLCs that have the similar name, and we wanted to clarify which one actually is the owner, and that is why that lawsuit was filed. And it's ironic that that lawsuit upon which this lis pendens was filed was not included in the record, but the consent order was, and the consent order specifically obtained the relief that Ms. Breeze was actually seeking, albeit we acknowledge that at this particular juncture, our client isn't in line to get any remedy at the point based upon the state of the appeal in Maryland. But that consent order specifically finds everything that Ms. Breeze was attempting to clarify in the record, specifically that the old REMUS entity did not own the property. Excuse me, the old REMUS entity was the owner.
Was the
And the
owner.
new one is not, notwithstanding what he's represented.
Notwithstanding what the lawsuit and lis pendens said he represented, the complaint says that that representation is false. Mr. Phillips' complaint says, and we're just taking the complaint as far as what it pleads, it says no such transfer has taken place. In other words, he is saying REMUS 1 owns the property, which is consistent with Judge Dason's order, as you just said, right?
Well,
Now, apparently subsequently, that changed. But looking as of the time of the filing of this complaint, and I take it the filing of, well, and obviously by that point, the lawsuit and the lis pendens have been filed. He is saying that the lawsuit is making false assertions that there was, that he said that there had been a transfer, and he is denying it.
well, I think first of all, we actually do have to look at the specific lis pendens, because I think
He's quoting from the lis pendens. Are you saying that that's not what the lis pendens says?
unfortunately, I have to
You don't have that
apologize.
either.
I don't
Well-
have it. It's not in the record. But I know that Ms. Breeze in her motion to dismiss stated that the object of filing she referenced the quiet title. And she said to obtain an order declaring Remus Enterprises, comma, 1 owns the subject property free and clear of any claims to any ownership interest or claim to the title by newly formed entity Remus Enterprises, 1 comma. That's in paragraph 10 of her motion to dismiss. And I do think one of the issues we raised in our brief was that this particular appendix doesn't have, and in fact, not a lot of this information is sufficient for the record, I have to submit.
You mean that there are things in both appendices that are not part of the record? Absolutely. And we look at the record.
I
Right.
guess I'm getting a little confused between the list pendants and the underlying lawsuit. Because I think you were trying to make a distinction there.
Yes, there were.
If the list pendants is quoting from the complaint on which the list pendants is based, then is the list pendants the filing that is slandering title, or is it the underlying complaint that is slandering title? It seems like the list pendants is just saying, hello world, there's a lawsuit out there.
Yes.
This is what the lawsuit says, but it's the lawsuit itself that is potentially slandering title or not.
That's correct. There were 2 list pendants filed. The first one we acknowledge, well, reluctantly acknowledge that.
To look at the complaint, I guess what I'm saying is the list pendants, if we look at those 2 paragraphs that we were just discussing, and the quote, right? I think I unfortunately have the amended complaint. I should have the original complaint, but you're saying it's 29 and 30, and the 29 says the list pendants further states that. Is that what?
Yes.
Right. So, and it's quoting something. So, I mean, maybe the list pendants does actually say Mr. Phillips claims that his new LLC has taken ownership, right? So actually, that's a true statement that let's assume that it's a true statement that that's what the list pendant says. But they're saying that the content of that allegation, which is what's being made in the complaint, is false.
Well, I think I'm assuming what Mr. Phillips is saying is that the complaint, the Nasi versus Remus Enterprises, where all we're seeking is a declaration as to who owns the 16.
I'm making a much more like
No, no,
pedestrian point of, to the extent that the second paragraph says defendant statements aren't true, they're not saying it's not true that the list pendants, that these statements weren't made in the list pendants. They were made in the list
They
pendants.
were made.
The question is whether or not it's true that, that there is this ownership dispute, and that's really the subject of the complaint, not the list pendants.
Right, I would agree with that. I think that the complaint does the first Nasi versus Remus lawsuit upon which this list pendants was filed does take issue.
I'm sorry, I thought this list pendants is referring to the lawsuit filed in DC.
Yes.
I thought you said the first lawsuit that he filed, which I thought was in Maryland.
I'm sorry, I meant in relation to this particular lawsuit that Mr. Phillips has against Ms. Breeze relates to the lawsuit that I believe was filed in DC, Nasi versus Remus groups, and that's why I referred to it as a first lawsuit. Sorry.
Didn't it come second in time, chronologically speaking?
Well, the Phillips, excuse me, the lawsuit.
Wait,
against
you
Mr.
meant, of course, yes, the underlying lawsuit on which the list pendants was filed is obviously precedes this complaint, which
Correct.
is about the list pendants.
Correct. So I said.
Yes, logically, that must be so.
Yeah,
Yeah.
this lawsuit was filed, I believe, in May
Yeah,
or
okay,
March.
we got that straight.
Yeah, so, sorry. So that's when I said that's the first lawsuit, but if I could, I think, if I may just get back to the standing issue, I think the consent order in our appendix, which is there in page number 10, clearly states that there's 2 different entities, old Remus and new Remus. Old Remus is the owner of the property old REMUS is the one that has standing to assert any potential claims against.
But so you're making, I mean, in this court, you're making an appellate standing argument,
Right.
right? You didn't make a standing to bring the lawsuit argument in the trial court, am I right? Or at least the trial court didn't address it.
I think correct, in part because this consent order predated all of that. I mean, postdated all of that.
Okay, well, putting that aside, the question before us is whether this court has jurisdiction from a standing standpoint to address this appeal. And your argument turns on allegations in the complaint that might relate to whether the plaintiff and was an aggrieved party below. But for purposes of appellate standing, would you agree that the plaintiff in the complaint was aggrieved by the trial court's ruling?
Yes, I agree that particular plaintiff who, again, didn't own the property, but had an adverse judgment or had adverse decision by Judge Williams granting of the motion to dismiss. I do grant that, but I would ask this court to take judicial notice of the consent order where the particular plaintiff doesn't own the property upon which was affected by the lis pendens and the purported conduct of Ms. BREECE, merely representing her client and attempting to get clarity on which of the two entities own the property, an issue that Mr. Phillips himself is confused in contradictory statements in his pleadings.
I'm sorry, the consent order says that the original REMUS is the rightful owner in fee simple of the subject property, right? And how is that inconsistent with, that is the entity that filed the complaint?
No, Judge Reese, the entity
It
that
is
filed
not.
the complaint is REMUS Enterprises, one comma. New REMUS,
The new REMUS.
yes. And Judge Dason said old REMUS is the owner of the complaint as of, and he could, this was a consent order.
I'm sorry. I thought you said the original complaint was filed by old Remus and the amended complaint was filed by new
I
Remus.
apologize. Both complaints were filed by new REMUS. And what I meant to say was Mr. Phillips, in the statement in his pleadings, convoluted the two entities. In his original complaint, he says that, I'll just, because I think it's an important point.
Can we just, yeah, it is. And look, can we stick with the original complaint? Because the amended complaint is not before us.
Right.
Oh, okay. So in the original complaint, he says in appendix 1, number 14, REMUS Enterprises, comma 1 LLC owns the subject property. That's not him. That's not the plaintiff. The plaintiff is one comma.
I'm sorry, the plaintiff is REMUS Enterprises, one comma.
Right. And in 14, if in the original complaint,
Yeah.
he says REMUS Enterprises, comma 1 owns the subject property, which we agree, but that's not who the plaintiff is.
So I mean, regardless of when the consent order was entered, you had an argument on a motion to dismiss at the time the complaint was filed that the plaintiff and the party asserted to own the property are two different entities. And you didn't make that argument in the trial court.
We did not, and I think part of the issue was we were trying to figure out what was going on. I mean, I know this is not in the record, but we believe Mr. Phillips canceled that entity intentionally to potentially take advantage of Mr. Nasi. I know that's not here. I know that we've got an adverse decision in Maryland. And then he creates this new entity in November. So we really didn't know what was going on and who owned what. I do admit we did not make that argument below, but I would ask this court to look at the consent order which he entered into, where he acknowledges that this plaintiff is not the owner of the property and therefore does not have standing to move forward on this claim.
Are you saying then that if we were to reverse, you would raise this standing issue on remand and so this would go nowhere? Is that?
Yes, I certainly would raise that. I've raised it in there's a lot of litigation between us. And I've raised that in other forums. It was successful in Montgomery County Circuit Court related to his claims or REMUS Enterprises claims against Mr. Nasi at the circuit court level. And he did not raise that on appeal.
Thank you.
Thank you.
Mr. Phillips, we'll give you just a few minutes.
Okay. So again, the consent order came out 8 months after the lawsuit was filed. The plaintiff in the lawsuit was the party that was aggrieved. They were the party that was entered into the contract to sell the property. They were the party that owned the property that went into the listing agreement. The trial court erred. The trial court decided an issue of fact, good faith versus bad faith, at the motion to dismiss level without any discovery. She found that there was good faith, and she says that in her order. Well, that's reversible error because she didn't have enough information before her to make that decision. So I would ask that the interference of contract be remanded back for discovery, for her to actually look at the whole picture to see whether or not there was bad faith. I guess at that point, the email would come forth where it says, just give us some money and we'll remove it.
You ask for discovery before ruling on the 12B6?
No, once when they filed a motion to dismiss, it was opposed, then she granted it, and I filed a motion for reconsideration of that and included all the evidence.
But what about the independent basis, which is that there was no allegation that the defendant knew of the contracts at issue?
There was an allegation that she knew. In the complaint, it says that the defendant BREECE knew plaintiff is in the business of buying and selling properties in the district and knew that the plaintiff would be listing the property
Right,
and selling it.
That's different. I mean, that's not the existence of an actual contract. That's just the possibility. And it's two contracts. It's a listing contract
And the
and a
listing.
sale contract. And that allegation alludes to a possibility that your entity might sell the property, might enter into both of those contracts, and a possibility that Ms. Breeze might know of the existence of that possibility.
So what's the question?
Well, the question is, for a tortious interference of contract, one of the elements is that the defendant has to know of a contract
Well,
of which they're interfering,
well,
and there's no allegation about that.
the law says they have to know either of an existence of a valid contract or other business relationships. And I believe that other business relationships mean a business relationship that will enter into a contract.
Do you have a
Here,
case to support that broad understanding of other business relationships? I would
the
imagine that it's
BLC,
to other business relationships that are in the nature of actual contractual relationships.
BLK LLC is a case that we cite to, but
We'll take a look at that case. Do you have any closing remarks?
other than that, the slander of title, again, at the time the Les Pendants was filed, the information in the Les Pendants is based on a falsity, and it actually contains false statements in the Les Pendants. And that, I think, is a prime example of a slander of title.
Thank you, counsel. We appreciate your arguments today. The case will be submitted. We're going to take a brief 5-minute recess and we'll be back in 5 minutes.
All right. This court will take a short recess to bring on the next part.
This honorable court is back in session. Please be seated and come to order.
Thank you for that break. All right, the third case on our calendar is 25 AA 278. JOKPA ONOJAFE et al. Versus DC Rental Housing Commission. Counsel, when you're ready.
May it please the court, Andrew McGuire on behalf of appellants, if I could reserve 3 minutes for rebuttal. May it please the court. This is a case of first impression. It addresses, obviously the court has read the briefs, a battle of two different statute of limitations. I would note that this also gives the court a chance to revisit the Loper-Bright versus Raimondo Supreme Court case, which has caused some consternation in this court with how much deference the court is to give agencies and their recommendations or their review of the law. And I know that the court has struggled with it, and I know that this panel can't adopt or create its own rules. However, this court has always been wary of giving too much deference to agencies and have repeatedly held that a regulation issued by an administrative agency must be consistent with the statute which it was promulgated. In this case, the RHC's, Rental Housing Commission's decision largely stood on its own definition, which they cited at DC Municipal Regulations 14-3899, which defined rent adjustment as, quote, any act by a housing provider that has the effect of increasing or decreasing rent, including an act to implement a rent surcharge. That that definition was put in 2021. It's entirely inconsistent with the DC code. The Rental Housing Commission's decision in this case starts out right at the beginning by saying something that's just simply not true, which says that the DC code doesn't define what an adjustment is. It couldn't be more wrong. The adjustments are strictly defined. There's only 7 of them. Each one of the 7, the word adjustment is used. So those are the only adjustments that exist in the DC code. So the agency wasn't really correct in saying, A, there was no definition, and B, they really had no place in sort of creating their own definition, which, at least with regards to the statute of limitations, sort of, at least in their view, expands all sorts of behaviors that might be subject
But
to.
your clients brought petitions before the rental housing agency, right?
So
And
they,
so how are those not at some level petitions for related to rent adjustments as opposed to some independent civil cause of action?
right, so the original agency is the Rental Accommodations Division, the administrator of regulations. The short answer is that that body has for dozens of years always entertained any act or any petition to challenge not just adjustments, but any rent that is wrongfully charged.
But let's look at the statute, right? The statute, DC Code 42-3502-06E says a tenant may challenge a rent adjustment implemented under any section of this chapter by filing a petition with the rent administrator, right? If we take what I understand to be your allegations as true, which is that this is a landlord who's never registered, never filed these rent adjustments, then are these rent adjustments actually implemented under a section of this chapter? Or are these kind of extra legal rent adjustments that shouldn't be going to the rent administrator at all because they didn't avail themselves of the regulatory scheme for rent adjustments, and you can go over to Superior Court and sue?
I think that the Rental Accommodations Division has probably concurrent jurisdiction with the Superior Court under the penalty clause for the Rental Housing Act, which is at 42-3509, which says any person who knowingly demands or receives any rent for a rental unit in excess of the maximum allowable rent. So that's the penalty.
Well, that they can be fined.
They can be fined, or the tenant can get a rent refund and or a rollback. So the Rental Accommodations Division, in my view, is really the only ones that have that jurisdiction to roll back. I mean, I suppose a Superior Court order to the Rental Accommodations Division saying roll back the rent would be effective. But I believe that the Superior Court and the agency have some jurisdiction over this. And I would just note that there's at least 6 cases that have reached the Court of Appeals that dealt with tenant petitions that were just about the initial rent, that there was no change in the rent. There was no,
Where were, I'm sorry, and they came to us from where?
let's see, Capuzza versus DC Rental.
From the commission?
Yes.
Okay.
So Capuzza is a famous,
We were talking about whether there's a remedy outside of the commission, outside of that whole agency context, going straight to Superior Court. Is that a possibility, given that this doesn't really seem to
I think,
cover this?
I mean, I suspect there is. I suspect, I mean, for example, we'll see this in landlord-tenant court, where a tenant might be trying to get some sort of rent credits back as against the unpaid rent for any
Housing code violations.
housing code violations,
Right.
correct. And in fact, I believe there are cases.
That's as a kind of a defense on the whole to an action for eviction for non-payment of rent, or, right?
Yes. So, but to your point about sort of this 42-3502.06E, it doesn't apply here. It doesn't apply here because we're not talking about adjustments. We're not talking about rent increases. We're not talking about decreases. We're not talking about any of the 7 statutorily defined adjustments. And if the commission is correct and basically any change in the rent is sort of their definition of what rent adjustment means, that doesn't comport with the rest of the statute, which says under any section of this chapter. So clearly the council, when they wrote this, new statute of limitations, was clearly directed towards rent adjustments under any section of the chapter. So they,
Right, so there's a way, I think, of harmonizing, right? The DCMR is purporting to define what a rent adjustment is, right? So you take, which is basically anything that changes the rent.
right.
Action.
And the problem is that's inconsistent with case law and with
Well,
use of code.
Well, no, the question is, rent adjustment is a phrase used in the statute. And the DCMR is defining rent adjustment. Okay, so it would still be any action implemented under any section of this chapter. I still don't see how you get out from having to use that other language.
So
The DCMR is not defining, per its terms, rent adjustment implemented under any section of this chapter, is it?
think in the RHC's opinion in this case, that's exactly what they did. They plugged in their definition.
I'm just looking at the language of the DCMR. So maybe I'm just saying that maybe the commission, what the commission's, one of the things that the commission, you could argue, did was incorrect, was to overread what the DCMR was saying, because if you just look at what the DCMR is purporting to define, it is only rent adjustment.
Right. So again, the 143899 says any act by a housing provider that has the effect of increasing or decreasing rent, including an act to implement it. So any act could be a landlord threatening a tenant, like I'm going to turn the water off unless you pay me more money, or I'm going to, break into your house and steal your food in your refrigerator. Like, according to this very broad definition, you could have a landlord come in and say, well, those are adjustments, and adjustments are there.
Isn't actually a permissible adjustment under, and you keep mentioning 7, and I might ask you at one point to just list what you think the 7
Sure.
Sections, 7 adjustments that can be made pursuant to the act are. But isn't one of them dependent on, a reduction in services?
Yes, that's 42350211, services and facilities adjustments.
Right,
These are all petitions that get filed. These are actually processes that are described. The section where this statute of limitations on adjustment appears, directly below it are the 7 adjustments. So I think just also contextually where the adjustments appear in relationship to this very unique statute of limitations. There's petitions for.
if the landlord had gone to the, I guess, where does it start with the
Accommodations division.
accommodations division, right? Thank you. And either petitioned or filed a notice, I guess, depending on the adjustment. Under which one? Maybe this is really a question for opposing counsel. Would it have fit?
Well, I think their obligation starts before we talk about adjustments, starts with registration. So a landlord who purchases a building and then opens it for business is required to get licensed and get registered. To this day, the appellee is not licensed or registered, which to me is shocking. And then to have the Rental Housing Commission come in and defend them essentially on page 10, saying, failure to register does not make a person an outlaw. Well, that's exactly what they are. I mean, the Rental Housing Commission, which is to oversee the Rental Accommodations Division, and implement and enforce rent control regulations and rent control laws, it's shocking that they would, in this opinion, basically say, oh, let's take it easy. This landlord is not an outlaw. But they've never registered. They're charging rents that are 220% higher than are legal. And they are trying to rely, their only reliance, their only defense is this statute of limitations,
They
which.
did not give required notifications to the net tenants.
Right, so after you register, there's also the notifications to the tenants that have to be mailed and posted. There's also notifications that go to all prospective applicants or applicants who apply. And none of these things were done. And, you know, again, to again, question about what deference is due the Rental Housing Commission is, you know, later on in their opinion, they talk about how, well, the tenants, they could have investigated these publicly available records at any time, which I suspect is true, but doesn't that obviate the whole point and laws of the DC code that require them to disclose this stuff up front? Hasn't the city council already determined like whose obligation it is, who has the primary duty to disclose these things? Yes, tenants can look stuff up, but that's not what the DC code says. The DC code says it's the obligation of the landlord to provide this information, which was never done because they never filed to this date. So I think to me, it seems perfectly clear just as a standpoint of reading DC code language. Am I out of time? I'm sorry.
Carry on. And we'd
Okay,
like-
is that we're not saying that there's no statute of limitations. We say that the statute of limitations that broadly applies to a 3-year statute of limitations broadly applies is the correct limitation here.
I want to understand that argument because,
Sure.
right, I thought that they were saying that the commission was saying it's a 3-year statute of limitations and you're saying, no, it's a.
No, it's a 3-year.
statute of-
Yeah.
So your point is, here's a landlord that has failed to comply with the whole regulatory scheme. They don't get the benefit of a statute of limitations under the regulatory scheme, which also, I'm gonna get the language wrong, precludes this kind of looking back.
Right.
Is that the right term? No, that's not the right term.
I think that's right. So I think that
The
the,
accrual,
The
that
accrual.
changes the accrual date.
It changes the accrual date, and you're saying if we go by sort of the standard statute of limitations for civil actions, the 3 years, then we're not limited by that accrual
Right.
limitation.
right, because of the doctrine of continuing harms,
what I
which
was looking-
applies to wages
Thank you.
and other things. And in fact, used to apply, and in our view, actually still does apply under the common law to, particularly in a case where a landlord is not registered and licensed. They've taken
To
themselves.
summarize, you're saying they don't get the protections of the regulatory scheme. We revert to the common law.
Yes,
If they're not going to avail themselves and comply with the regulatory scheme. If they comply with the regulatory scheme, then, you know, any rent increases, decreases that they registered, notify, people can challenge them in the usual way, have the 3-year limitation. And that operates as usual. If they just are complete scofflaws, then no, we get to operate outside the regulatory scheme. And I guess my question is your point then that this still gets litigated before the Housing Commission, or have you sort of argued yourself out of an administrative forum into Superior Court?
no. So I was thinking about this yesterday. So if I drive without a license in DC and I get arrested, I'm still, if I hit a pedestrian or something else, I'm still subject to all the penalties. I'm still subject to motor vehicles. They can put points on me and I can never get a license in DC. So the agency, the underlying agency that oversees all rental housing, it doesn't matter whether it's registered or not. They oversee all rental housing. They have to. Otherwise, if landlords could choose to not be regulated, then none of them would be regulated. I mean, all of them would choose not to be. So their task, and it's difficult, is to ensure that all landlords are.
From a
are
policy standpoint, we don't want to open the barn door to force people to go to Superior Court. We want to keep the landlords and the tenants.
Well, the incentive would still remain to be regulated. I mean, to register and subject yourself to regulation so that
Yes.
you can take advantage of the
Yeah.
3-year statute of limitations.
Yes.
Right? So that incentive would remain,
Right.
even if, in fact, it might you might think, it would be greater if, quote, the threat is, I'm going to be sued in Superior Court.
I mean, I hear what you're saying about Superior Court. I do think that there's probably two forums. I can imagine the first question a Superior Court judge would have for me if I brought this case there would be like, shouldn't this be
What do you
with the
do
rental
here, right?
accommodations division? But
recognizing that, Hobson's choice, I guess, if you will, once your clients, perhaps for lack of a better option, went through the, not remember the name of the rental agency at the initial level.
yeah.
The accommodate, the,
Rental accommodation. RAD,
yes, thank you. Why are they not at that point subject to the statute of limitations that is reflected in the governing statutes for those
Okay,
proceedings?
I see what the question is.
Yeah.
So that statute of limitations that statute, it doesn't apply to everything that goes before the rental accommodations division. So for example, rental accommodations deals also with return of security deposits, claims of retaliation. So there's lots of things in the rental accommodations division in their bailiwick that this particular, statute about adjustments, no one would even say, hey, that applies to retaliation or that applies to return of the security deposit. So this is the only statute of limitations in the entire Rental Housing Act. Certainly the council could have added other ones for different kinds of things. They could have added something that said unregistered landlords only have, 4 years or 3 years.
And so if a client, if a party brought one of those other types of claims that you just mentioned,
Yeah.
examples, in the rental accommodations division, is it the civil standard 3-year statute of limitations that applies? Is that-
I believe so, yes. I mean, I believe that there has been some RHC opinions that have sort of dealt with some of these issues with regards to diminishment of services and facilities. When did that occur? Is that an adjustment? And I think it is fair to call that an adjustment because that is an adjustment that's specifically in the DC code. Retaliation is not an adjustment. There is no adjustment for retaliation. So I do think that to answer your question is yes, that they would look at the general applicability statute of limitations in 12301 because I mean, that's also the reason for that. That's the catch-all. So anything that doesn't have a specific, and this is not anything revolutionary. I mean, this is the whole point of statute of limitations is this one would apply unless there's something specially applicable to the conduct that's being alleged. So
Is there a presumption in terms of interpretation? I think you referred to that somewhere. Maybe it was an estate case, is that correct? That you cited in terms of when there's a question, you kind of go for the statute of limitations that would permit the action to
yes.
proceed?
I believe in our brief, we talked about how, well, first of all, the statute of limitations is affirmative defense. So the burden is usually going to be on the party asserting it, which we don't believe has really been established. And secondly, that there is a general concept that under the courts should try to, if you have two competing statute of limitations, give the litigant the one with the more time. And that's just common law under the District of Columbia.
Now, I believe we have said, perhaps referring to the legislative history behind this special statute of limitations, that the purpose of this was not to benefit landlords, but for the, in a sense, a convenience or not to overburden the agency in terms of how far back they would have to go
Yeah.
in looking up records and making calculations. How does that purpose figure into your argument?
Yeah, I mean, it makes perfect sense. I mean, when you look at the cases, Kennedy and United Dominion, Kennedy in particular, the tenants were trying to, in 1994, were trying to challenge a rent ceiling adjustment from 1986. So they were going back 8 years. And their theory was, well, that one was wrong. And therefore every other increase, which might have been correct, those have to be readjusted. And I could definitely see that the council coming in saying, we can't have that. We can't have every adjustment going back 20 years be reexamined. So I think that the purpose of it was, is correct and is generally upheld. But in this case, there is no, we're not looking back. In fact, what the
You would
appellant,
be looking back.
well, the appellants are looking back to the last rent ceiling, which is from 2007. So it's our side who's saying, let's just open the books, see what the legal rent is, and that's,
How far, if you were not subject to this special statute of limitations, how far back would the agency have to go to adjudicate your client's claims?
well, I think we go back to the last filed, the last time.
2007? 2007, is that what you said?
Yeah, 2007 was here, but I mean, I've had cases where we were looking at.
So 19 years, they'd have to go back
Yeah.
19 years?
And again, we're not really going back. What we're doing is that.
I
because-
know you're not asserting you would only go back 3 years.
Correct.
for
So
claims,
the
but in
07
terms of the burden on the agency to calculate
correct.
the overcharge.
Correct. I don't think that's applicable here because, and I don't think it would be applicable anytime you have an unregistered landlord. If you can go back in time and find a registration and a rent ceiling that was established, which we've established in the petition itself, the appendix, at 36 is a printout. Now, this is all the way back with the rental accommodations. This is the original petition. Shows a printout, and it shows sort of the last filing is from 2007, which means that the agency, which has control of its own records, knows that there has been nothing filed in this case since 2007. So that problem that this statute of limitations was designed to address, which is going back and leapfrogging over a bunch of correct legal adjustments to find some, incorrect illegal adjustment 18 years ago, that's not this case.
So how would they figure this out? They would assume that the general, let's say, cost of living adjustment could have been done, and they bring it forward from 2007 and say, this is what it would have
No,
been?
because those,
How do you figure out what the proper maximum?
the proper maximum is what's posted, it's what's filed. So landlords don't have
Only
to take-
2007.
2007, yeah.
They would be stuck with that amount.
Yeah.
They wouldn't get the benefit of anything they could have, but should have, but didn't do.
Correct. And landlords are not required to ask for adjustments. I can own an apartment building and I might be entitled to take the
And not do
CPI
it.
plus
Sure.
2% adjustment every year. I could choose not to.
Of course.
And then I can't 5 years or 10 years later say, now I want to go back and redo all of those things. So I think the answer to your question is that we're
Because
standing.
if you had foregone, let's say for 10 years or 5 years, and then you want to do the adjustment, you can only use that last year's
Yeah.
COLA.
That's
You
right.
can't accumulate all.
That's right. So in other words,
Okay.
if this particular landlord had decided to do an adjustment of any kind, capital improvements, increase in facilities, they would be petitioning RAD to increase from the ceiling, which was established in 2007. That's it.
But they couldn't, for example, ask to increase because we made all of these improvements since 2007, no?
Yes, I mean,
Good.
they could.
Even if it wasn't the last year.
They could, but it would only be, it would be, again, an increase off of the 2007 established rent.
Sure, but, okay.
And if your question is, what if they spent 3 years doing some sort of construction or rehab? Could they pour all those 3 years into one capital expenditures petition? I think the answer is yes. I don't know for sure, but I don't think that these
But they
laws,
could not accumulate the COLAs.
I don't think they can accumulate COLAs. No, that I'm fairly certain that's not true.
Okay.
All right, counsel, we will
Sure.
let you take a seat and we will hear from Mr. Sokolow.
Your Honor, may it please the court, Aaron Sokolow, I represent the intervener in these consolidated appeals. Opposing counsel keeps repeating this phrase. It was the first thing he said today. It's in his brief as well, that this is a matter of first impression, but it's not. All of the arguments by the tenants in these appeals are regurgitations of cases that this court has already decided. The first being Kennedy, that was nearly 30 years ago. And the Kennedy case is definitive, that says that the enactment of the statute of limitations that applies to rent adjustments does away with the old McCulloch era.
Was the housing provider registered in Kennedy?
In Kennedy, yes, but not in the cases that stem therefrom, such as recently as the Pearson case and the Nimri case. So this whole attempt to distinguish between
I'm sorry, the Pearson case and the,
Nimri, NIMRI, the entire attempt to distinguish between cases where the landlord is licensed or unlicensed is an entirely arbitrary distinction. And this Court of Appeals has previously said that the statute of limitations applies even to unlawful prior rent adjustments. It does not matter. Those are all merit-based challenges, and the statute of limitations precludes those merit-based challenges if the increase took place more than 3 years prior to the petition, which undoubtedly it did here. There was an entire conversation with Judge Ruiz on your line of questioning about these increases that can be taken. Nothing in the Rental Housing Act limits the amount that can be charged for a rental unit. That's not how rent control in the district applies. It only limits the increase that can be taken at any given time. The entire system is predicated on
Over
the
the
concept of
prior rent,
adjustments.
over the prior rent,
Exactly.
which is why it's significant, well, over the prior rent actually charged or over the prior maximum allowable rent?
Great question.
Thank you. What's the
It's-
answer?
The answer is that the tenants would have you believe that it only applies to the lawful rent, so that they can mine records going back 30 years and say, if I can find some mistake in registration back then, if I can find some mistake anywhere,
not
then
mistaken registration, just no registration.
it's the same, Your Honor. Registration is binary. And this is very evident across the street in the landlord and tenant court, where in 2025, before the enactment of the Rental Act, if there was any problem with your registration statement, the judge presiding would say, this registration is flawed, it's invalid, case
No,
dismissed.
but when you say registration, is that the same as a particular rent? Or are they two separate things?
They're separate. There are
That's
three
what I
pieces
thought.
of
I thought-
registration.
right.
Your business license for any multifamily, you need a certificate of occupancy. And then you need the registration statement. It's the same statement for registered or exempt properties.
Right, and I thought we were talking about a specific allowable rent.
So unless the landlord is licensed and registered, you cannot increase the rent. So when opposing counsel says, everyone will just not register, great. This housing provider hasn't raised the rent in 12 years because for a variety of reasons, which aren't in the record, and I'm happy to elaborate on, they can't get registration right now, or registration has been delayed in large part through actions of the tenants who, for instance, deny access to a DOB inspector, and then DOB won't issue a business license. Then I can't go to the online rent registry and file my registration form. So there's a variety of reasons. This is not hey, I'm going to profit by failing to register. It's a complete detriment to a landlord to not be registered. And now there are licenses for some of these units for whatever that's worth. However, if I don't have full license and registration, I can't go across the street and file a landlord and tenant complaint. I can't raise the rent, period. But the way that the tenants are arguing this, they want to say that if I can find any technical reason why your registration is invalidated, I can now go back to the last rent on file. 30 years ago, that rent was charged, and I can now say that the rent was illegally increased. And maybe I can't get all of that rent back, but I can get the last 3 years of rent back, rolled back to a 2007 level. That's the exact scheme that we had in McCulloch that our court and our legislature outlawed by passage of the statute of limitations. And the tenant's position in this case would go back to that exact same framework.
Okay, getting back to a more pedestrian, and I appreciate what you've just said, but just reading the statute, which is kind of what we do, look at the language and then look at the DCMR. A tenant may challenge a rent adjustment implemented under any section of this chapter. Pursuant to which section of this chapter were these rent adjustments implemented?
I believe they would say that it was implemented under the general applicability statute, that,
They would say, nobody has said.
well, I mean, the general applicability is the increase that you can take every year. So,
Is a COLA adjustment.
yes, yes. And when my client purchased these properties at a bankruptcy sale, they thought they were taking, you know, the ordinary adjustment that was permissible.
No, it wasn't a vacancy adjustment.
I don't know. That's not in the record. That happened in
But the
2014.
but the point is that the statute refers to a particular section under of this chapter, and we can't even right now identify under which section it has actually been implemented. At most, you could say, maybe it could have been this, or maybe it could have been that. And how is that consistent with the language of the statute?
My position is that any adjustment between a landlord and a tenant is covered by one of the adjustments.
your
into the
position.
rental housing.
Okay, but I'm reading the statute.
Well, then the tenant petition should have been dismissed on that basis. I mean, as the Rental Housing Commission said, the tenant can't have it both ways. Either they filed a petition under subsection E, which says that they can challenge a rent adjustment, and then they're subject to the rent adjustment statute of limitations, or they misfiled and they couldn't have filed a tenant petition and they're not, you know.
Well, not with the rental administrator.
That's where they filed.
Okay, so maybe they filed in the wrong forum?
I don't believe they did. I believe that a rent adjustment is a rent adjustment is a rent adjustment. Those are commonly used words. So I don't believe that we need to go,
Well, I know,
I mean,
we have
adjustment,
look,
adjust.
we're just judges here, you know, we just read statutes and we read the words and we try to give effect to what they say. All right?
Rent adjustment is something that adjusts the rent. It went from A to B, and that's what
That's
they are
the-
challenging.
Yes, but but the statute of limitations says a rent adjustment implemented under any section of this chapter.
And this was,
We know that literally it wasn't implemented under a section of this chapter because there has been no for whatever reason, there's been no registration, no notification, no whatever. By the way, why wouldn't there have been notification, even assuming that, as you say, you've been held up in your registration?
notification was the execution of the lease. They
Oh, I
signed
thought
the
there was
lease.
supposed, I thought the notification was supposed to give information about prior rents.
That's not in the record. So I don't know what these tenants allege they were or were not given in 2014 when they signed the lease. I don't know. That's
Mhm.
not in the record.
But
I
you
wasn't-
agree that notification would require that, proper notification would require some notice of what the prior rent was and what the current rent is.
I'm not sure if even I understand what we're talking about when we say notification. These tenants received notification because they signed a lease that said, this is your initial rent. But that was an adjustment over prior rent. It's not in the record what the tenant prior to them was paying. I don't know if it was an increase
I
between the
thought
two
there
or
were
not.
regulations about how adjustments could come about. And
That-
that includes giving people notice of what the adjustment is, what the old rent was, what the new rent is.
If you're
Right.
there for
But
more
we
than,
are in a scheme where this is supposed to be sort of a tenant-friendly, interpose the rental administrator in between the tenants and the landlords, right? So we're requiring the landlords to do things and to give information to the rent administrator and to the tenants.
so there are many different ways that a rent can be increased in the district. If a tenant is there for more than their initial lease term, then there is a form promulgated by the Rental Accommodation Division that says, here's your notice of rent adjustment. I'm a registered landlord. Here's the section under which I'm implementing the increase, and here's the percentage in the math
So
worksheet.
that goes to the tenant and it goes to RAD.
That's right, but that would be if the rent is being increased during the tenancy after expiration of the initial lease term. That's not what occurred here, because these tenants have never once had their rent increased from the date
So
they moved in.
Is you're saying that at the time these tenant or the first tenant, let's say 2014, signed their lease, I mean, the RHC said that it was on them to, the 2007 rent was public. It was on them to find that out. And it's your position that there's no notice requirement when they signed their lease in 2014 of what the 2007 rent was?
I don't know the answer to that, Your Honor, and I do this every day. I don't believe that there's a requirement when a new tenant signs a new lease that the landlord has to give information to the new tenant of prior rent levels. I'm not aware of that as we stand here today. That wasn't part of the briefing. I'm not aware of that. No.
I thought that 42350213 says that in new leases, as part of a lease agreement for a new tenancy, the housing provider shall disclose to the tenant on a form published by the rent administrator, one, the rent charge for the rental unit at the commencement of the tenancy, in other words, what's on the lease, the amount of the increases in the rent charge for the rental unit during the preceding 3 years, including the basis for each rent adjustment.
If that's what the statute
That's
says,
what the statute seems
Okay.
to say, yeah.
I don't know if that was in effect in 2014. But I mean, the statute is what the statute is.
Right.
I don't believe that the tenants can succeed on this appeal by arguing that the Rental Housing Commission erred when it looked at the regulatory definition of the word adjustment, or would have this court believe that we don't all know what the word adjustment means, or that we should overlook the statute that says that they can only challenge a rent adjustment.
But Mr. Sokolow, even as, I mean, maybe tell me why this reasoning of mine is incorrect. The DCMR purports to define rent adjustment, right? Those two words, that phrase, as meaning basically anything that puts your rent up or down, right? Okay, so now we take that definition and plug it into the statute, which still says a rent adjustment implemented under any section of this chapter. Okay, so those words don't disappear because the DCMR has defined rent adjustment.
No, I agree.
Okay,
But I believe that any rent adjustment would fall under a rent adjustment under this chapter.
how does it fall on, you're saying that any rent adjustment is pursuant to this chapter?
Yes,
By
between a landlord
why?
and tenant in the District of Columbia, because if it's not, then the tenant can't
So those
challenge.
words mean nothing.
No, I mean.
Well,
there-
what do they mean?
There,
What rent adjustments would not be covered? Let's put it that way then.
rent adjustments would not be covered.
Right.
An exempt landlord would not be covered. A
Well-
landlord who is qualified for and has obtained an exemption is not covered by this. And so that's why there's not jurisdiction to examine those rent increases before the office
Okay.
or the rent administrator. I mean, I think that's specifically what they're talking about. This covers everything that's not exempt.
Non-exempt just means you're not under the statute at all.
No, it means that you're not limited under those rent increase limits.
Mhm.
And that's a huge subsect of landlords in the district. And usually when we see tenant petitions, it's challenging the validity of an exemption. And that is why the tenant's position is so, it's so monumental. Because if I mean, I've had cases before the Office of Administrative Hearings, the Rental Housing Commission, and this Court of Appeals, where the tenant's entire case is, I don't believe I received the claim of exemption, and that should invalidate the exemption. You're actually a subject landlord, and therefore the rent increase that you implemented in such and such time that was in excess of the COLA that you thought you were entitled to as an exempt landlord is actually wrong. And I've had cases hinge on whether that exemption form was mailed, because the famous case of Caramel, if it wasn't provided to the tenant at the time of filing, it invalidates the exemption. And if the court finds that exemption was invalidated, you're not actually exempt. In fact, you're not even actually registered. It invalidates the entire registration. Well, now the tenants will have If any tenant can find that that was the case 10, 12, 15 years ago, I can file a case. You're not licensed, you're not registered. I can challenge this. And maybe I'm not entitled to 15 years worth of rent, but I'm entitled to the quote unquote overcharges for the last 3 years. That's the exact scheme that we had in McCulloch. That's the exact scheme that this court has said that the statute of limitations was intended to stop. That's been since Kennedy almost 30 years ago when they said we need to stop tenants having the ability to go back decades to look for any discrepancy in any form, to invalidate license, invalidate registration, invalidate an exemption for any purpose. And I'm now entitled to a refund of all of the rents that accrued, the alleged overpayment of rent for the last 3 years. In this case, these tenants agreed to these rents almost a decade ago. And they want your honors to go back to 2007 to look at what some rent level was so that they could go file a new case in the DC Superior Court and be entitled to tens of thousands of dollars of rent refunds because the rents that they agreed to in 2014 were in excess of what is on file from 2007. And now they want to say, okay, well, give me
Counsel.
3 years worth of that.
I think we have your argument.
Thank you very much, Your Honor.
Thank you very much.
I'll try to be very brief. Just to Mr. Sokolov's last point, if his client had simply registered, he wouldn't have any of these complaints. So he's asking for you to share in his outrage at this, but it's really his client's own conduct that puts the client in that position. Second point, with regards to RAD or Superior Court, or does RAD have jurisdiction over non-rent adjustments, but simple overcharges? Again, the appendix at 32, I put in one of the tenant petitions, and this is a form that is generated by RAD, Form 23, and you'll see that the only boxes that were checked were A, that the building is not properly registered, and H, that the rent charge is in excess of the rent ceiling for my rental unit. So if with this form, this is certainly appears to be RAD inviting tenants, fill in the box. We obviously have jurisdiction to handle these kinds of claims. There's retaliation in here. There's failure to return security deposit. Last point is the Pearson case, which Mr. Sokolov, I think, mistakenly identified as one where the landlord was not registered. In fact, she was registered. She was registered and was declared exempt, or declared herself exempt as under the small landlord exemption. And that was a tricky case from the standpoint of this statute of limitations thing, because clearly she did increase rent, and that's ultimately how this court decided that case, that those rent increases were adjustments. They certainly weren't adjustments under the DC code, but because her exemption had not been perfected, the court kind of looked at her as, you're registered, but you don't have an exemption. And so what he started out by saying is this is not a case of first impression, that we have lots of cases, I guess, involving unregistered landlords. It's just not true. Kennedy was a registered landlord, and it was tenants challenging a rent adjustment. Madgerly, which is a great case because there's 3 of them, was also a registered landlord, again, talking about adjustments in the rent ceiling. United Dominion, same thing. Nelson, the same thing. So all of the cases that they rely on, which are all good law and all make sense from the standpoint of registered landlords who are year after year filing new rent adjustments, most of them with the COLA, that we shouldn't have tenants be able to go back 7 years, 8 years and challenge something that happened 10 years ago. But we're not challenging something that happened 10 years ago. We're saying this is the rent level that's on file, and that is the most that this landlord may charge legally.
In 2007.
From 2007. And for the courts or for the Rental Housing Commission to uphold the collection of unlawful rent, I just think is a betrayal to what its statutory mission is. Thank you.
One quick point. Mr. Sokolov made the point that they were trying to register and somehow it was your clients that were preventing that. That none of that is before us, but if such a situation were to arise, how would that be dealt with? Let's say you go in, you say you still go before the agency, but you're not subject to this special 3-year statute of limitations because you claim they're not registered and haven't been operating within the system as they should have. So what, there at that point, the landlord comes in and says, the reason why we haven't been doing that is because you prevented us from doing it, and therefore, yes, the special 3-year statute of limitations should apply?
Well, obviously, my clients haven't stopped them from registering. They could have and should have registered and got their license when they bought this property before any of the tenants moved in. I'm not sure what Ms. Chocolate is referring to as far as they've since tried to register or since tried to get licensed. And my clients have,
I was posing a hypothetical.
yeah. Can you repeat the
Do
hypothetical?
you think there's a process by which, if the tenants came in and said, we're not subject to the statute of limitations because the landlord is unregistered, and the landlord says, we're only unregistered because we've been obstructed by the tenants. Do you
Okay.
think there is a forum, would the Rental Housing Commission be able to consider that defense to non-registration and,
So-
request for the statute of limitations to apply?
I understand that question. Ms. Chocolate could probably speak to this better than I know this happens in landlord-tenant court all the time because you do have landlords who have tenants that have never paid rent and they're trying to put them out. And the defense is, well, you don't have a license. And then the landlord will say, but you won't let us in the house in order to inspect it. That does happen fairly often. I don't know what the answer is. I suspect that you have to get some judicial relief to order the tenant to give access, or there might be a way to, again, through judicial relief, get a presumption, which is that because the tenant has barred access, they can't then rely on the lack of registration or lack of
Right.
licensing. But there's certainly nothing in the record to suggest that that was why this landlord has been unregistered since purchasing this property all those years ago. But I understand the question. I just honestly don't know the answer to that.
Thank you.
Thank you.
Thank you, counsel. We appreciate your time before us today. In this case will be submitted and we stand adjourned.